The chair lays out Senate Bill 2972 as a matter of postponed business on second reading. The clerk will read the bill.
SB 2972 by Creighton relating to the expressive activities at public institutions of higher education.
The chair recognizes Mr. Leach for a motion.
Thank you, Mr. Speaker. Members, we're still working actively, several of you and with our Senate counterparts, on some changes to this bill. So I move to postpone further consideration of Senate Bill 2972 until 8:15 p.m. tonight.
Members, you've heard the motion. Is there objection to the adoption of the motion? The chair is none. The motion is adopted. Chair lays out on second reading Senate Bill 2206. The clerk will read the bill.
SB 2206 by Betancourt relating to a franchise tax credit for and the application of sales and use taxes to certain research and development expenses.
The chair recognizes Mr. Guerin.
Thank you, Mr. Speaker and members. Senate Bill 2206 extends the R&D franchise tax credit program and repeals the inefficient sales tax exemption. I move passage.
Members, the question occurs on passage to third reading of Senate Bill 2206. A record vote has been requested. The clerk will ring the bell. Show Mr. Olcott voting nay. Have all members voted? Show Mr. Patterson voting nay. Show Mr. Anchia voting aye. Have all members voted? All members voted. There being 106 ayes, 36 nays, Senate Bill 2206 passes to third reading. The chair lays out on second reading Senate Bill 457. The clerk will read the bill.
SB 457 by Colcourse relating to the regulation of certain nursing facilities, including licensing requirements and Medicaid participation requirements.
The chair recognizes Mr. Frank.
Thank you, Mr. Speaker. Members, there are over 80,000 Texans in nursing homes, and more than 60% of those, well more than 60% of those are covered by Medicaid. The state pays over $6 billion each biennium in caring for these seniors. I'd like to take a few minutes to explain the bill because it does have an impact on people, and I know when you're spending $6 billion, there's a lot of lobbyists that have been sending out a lot of information on this, and I do have two amendments, one for myself and one from Chair Rose. The overall purpose of SB 457 is fairly simple. It is to increase accountability for taxpayer dollars and increase the quality of care for those 80,000 residents in the state. It does it by two things: an ownership disclosure, straightforward, we need to know who owns these, and the second is it incentivizes high quality care. Some of these folks have been saying that it's this hard mandate. If the nursing home has a 4 or 5 star quality rating, there is no mandate. If they don't, we want to see that 80% of the money is being spent on the care of those clients. Pretty straightforward. We're spending $6 billion. There's 80,000 residents. I think, y'all think, the money should be spent well. Just so you know the lay of the land, there are 4 groups that represent nursing homes. 3 of them love this bill and are working hard, working y'all's phones hard. There's one of them that has been unwilling to negotiate almost at every turn and is telling y'all it's terrible. But I promise you it is not, but we need accountability for how the money is spent. With that, I would like to lay out an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Frank.
Chair recognizes Mr. Frank to explain his amendment.
Thank you, Mr. Speaker. Members, this does 2 simple things. In the negotiations, we are making sure to add housekeeping staff to part of what is taking care of the patients, and it certainly is. It's more favorable to the nursing home, so we're adding that. And also, we make some changes to the quality. And again, the quality metrics, which are CMS, the national quality standards, 4 and 5 star ratings, and so that's what this changes. It is acceptable, obviously. It's my amendment. It's acceptable to the author.
Mr. Frank sends up an amendment. It is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Mr. Frank voting aye. Show Mr. Capriglione voting aye. Show Ms. Rose voting aye. Show Mr. Schofield voting aye. Show Mr. Anchia voting aye. Have all members voted? Have all members voted? There being 140 ayes, 0 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Rose.
Chair recognizes Ms. Rose to explain her amendment.
Thank you, Mr. Speaker. Members, the change of ownership process for nursing home facilities can take months. And so during the time, providers are not reimbursed by Medicaid, but continue to provide the services to our most vulnerable Texans. And so my amendment ensures nursing facilities can continue to receive Medicaid reimbursements during the time of change of ownership, and it's acceptable to the author.
Ms. Rose sends up an amendment. It is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Ms. Rose voting aye. Mr. Frank voting aye. Mr. Caprileone voting aye. Mr. Leach voting aye. Can't vote twice. Have all members voted? Have all members voted? Show Mr. Anchia voting aye. There being 124 ayes, 15 nays, the amendment is adopted. The chair recognizes Mr. Frank to close.
This is great for the 80,000 residents of our nursing homes. I move passage.
Members, the question occurs on passage to third reading of Senate Bill 457. A record vote has been requested. The clerk will ring the bell. Show Mr. Dean voting aye. Have all members voted? Have all members voted now? Show Mr. Anchia voting aye. Show Ms. Gervin Hawkins voting aye. Have all members voted? There being 116 ayes, 24 nays, Senate Bill 457 passes to third reading. Chair lays out on second reading Senate Bill 2337. The clerk will read the bill.
SB number 2337 by Hughes relating to the provision of proxy advisory services in connection with certain entities domiciled in the state.
The chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, Senate Bill 2337 deals with companies offering proxy advisory services, often referred to as proxy advisory firms. These firms provide services, important services, to corporations and institutional investors. An institutional investor may be, and often is, invested in hundreds or thousands of companies. So they rely on, these institutional investors rely on these so-called experts to satisfy their fiduciary duties to shareholders and hire a proxy advisory firm to do this research for them and to make voting recommendations to the shareholders. Recent evidence has shown that these firms are basing their advice to clients on factors other than shareholder return, in many cases such as environmental, social, and governance, ESG, and or DEI factors. This has led to many instances where a single proxy firm has given one set of advice to a company and the complete opposite advice to one of its investors on the very same issue, one of its competitors on the very same issue. So members, for example, and this is important, let me break this down for you very, very simply and shortly. For example, a proxy advisory firm may recommend both for on a specific vote, for to one company and against another company to the same company proposal on, like, let's say, a director nomination or on a merger or acquisition. All of this while that proxy advisor firm knows that with each of their clients, they owe fiduciary duties to maximize financial return. So members, these proxy advisory firms are justifying their own subjective, independent, and often irreconcilable advice, giving one firm one set of advice and the other firm, its competitor, a totally different set of advice on the basis that they themselves don't owe fiduciary duties to the shareholders. So this bill in front of you now requires firms to disclose whether their advice is based on non-economic factors or if they're giving conflicting advice to different clients. The bill also provides an enforcement mechanism through the existing DTPA and Declaratory Judgment Act procedures and remedies. I do have an amendment.
Mr. Speaker,
Ms. Goodwin, for what purpose?
will the gentleman yield for some questions
Gentlemen, yield for questions.
prior to the amendment?
Okay. Yes, I yield.
The gentleman yields for questions.
Thank you. I appreciate that, Representative Leach. have been trying to understand this bill a little bit better. And you, in your layout, you were saying that the investment companies might tell different investors, give them different guidance. Isn't it true that different investors may have different goals for their investments? And that might be why they're given different advice.
The shareholders, the proxy advisory firms owe fiduciary duties to the shareholders of the companies. Fiduciary duties are defined in statute. In many cases, they are not subjective, they are objective. Fiduciary duties are clear. And when you're basing your advice on a vote, let's say to one company for and another company against, based on factors other than fiduciary duties, that prevents a very real conflict, and I believe an irreconcilable difference that this statute is meant to correct.
Isn't it true that different investors have different investment styles, risk tolerances, investment horizons, and preferences for investments in certain geographic areas or business sectors? Does your bill take that into account?
No.
don't you think that that is an important part of being a good fiduciary?
I don't understand the question, Representative Goodwin.
Isn't it common for different investors to look at an investment and have different perspectives on its merits? For example, one stock analyst looking at a stock and rating it a buy, while another analyst doing its own analysis and rating the same stock a sell.
Sure, and all this bill is seeking to do is to require firms to disclose in those situations when their advice to a company, to its shareholders, is based on non-economic factors.
Okay. Wouldn't it also be true for how different investors might evaluate the merits of any proxy voting agenda items?
The proxy advisory services can, the companies, the firms, I should say, simply have to disclose. And where there is enforcement that needs to be done, this bill provides enforcement mechanisms through existing DTPA and Declaratory Judgment Act procedures. So, if there are proxy advisory firms that want to hide and toward not disclose, to tell one company to vote one way and another company to vote another way based on non-economic factors, then they're not doing their duty to either company, to the shareholders of either company, because the shareholders are not aware that a proxy advisory firm that is advising them to vote one way on one vote or on one issue is advising their competitor and or another company to vote another way on the same vote. And so what this requires them to do is to disclose that conflict.
So you're saying that it simply is saying they have to tell the investors why they're giving a rating or giving advice, what the basis is for that advice. That's all. But then you also mentioned a penalty.
Yeah, there's enforcement mechanisms, and so where a proxy advisory firm, realize these shareholders, in many cases there are thousands and thousands of shareholders that truly are, in many cases, wholly and entirely relying on the advice of the proxy advisory firm. So when they're relying on that advice, they are relying on that proxy advisory firm to know and to intentionally fulfill their fiduciary duties to the shareholders. And when they are going outside of those fiduciary duties and they are basing their advice to the shareholders on other non-economic factors, that is where we believe, and the bill provides that the shareholders should be, that should be disclosed. And that's all the bill is required to do. And where it's not, where that's not happening and shareholders are being misled, and there are clear and irreconcilable conflicts of interest, then there are enforcement mechanisms built into the bill.
So it seems like your bill is really just trying to call out when they are taking ESG factors into consideration. Is that true?
No.
All right. Thank you, Representative.
Thank you.
Mr. Speaker, will the gentleman yield for questions?
Gentleman, you for questions?
Yes.
Gentleman yields.
Thank you, Mr. Speaker. Thank you, Chair Leach. I'm interested in the DTPA provisions of this bill. I think it's on page 7. Could you explain, is this a existing provision within our current DTPA statute?
You're right, it's page 7, lines 11 through 14, regarding a Deceptive Trade Practice Act. Under subchapter E, chapter 17, the Business and Commerce Code, it would be actionable under section 17.47 of the Business and Commerce Code.
Yes, sir. And that's, I mean, we have a Deceptive Trade Practices Act, but this would be a new cause of action under that?
The statute speaks for itself, Representative Martinez-Fisher.
Well, it does, but I'm just trying to clarify. I mean, if it's, we don't currently have that enforcement mechanism now, do we?
The statute speaks for itself.
What's it saying?
You just identified the lines, Representative Martinez-Fisher.
Okay.
You can read. In fact, I just read them for you.
Thank you. Well, I appreciate that, Chair Leach. With regard to your DEC action, your DEC judgment for injunctive relief, the affected party, I'm trying to understand that section. Can you explain that to me?
Sure. The declaratory judgment or injunctive relief section, again, very self-explanatory, very simple and easy to understand. The term affected party includes the recipient of the proxy advisory services provided by the proxy advisor, the company that is the subject of the proxy advisory services, or, not and, but or, any shareholder of the company described by the company that is the subject of the proxy advisory services. And it says in the following section that any affected party, as I just defined, can bring an action, a deck action, under Chapter 37 of the Civil Practice and Remedies Code.
Okay, and then is it common in our statute for the Attorney General to have the ability to intervene in an injunctive action for shareholder matters?
For the Attorney General to be able to?
Yes, sir.
I don't know if, what was your question? Is it common?
My question, I see that provision provided at page 8, line 1. I didn't know, is that common within our injunctive relief statute to give the Attorney General the ability to intervene for shareholder matters?
I don't know the answer to that, Representative Martinez-Fisher. I don't know if it's common, but here there is the ability to notify the Attorney General and the ability of the Attorney General if he or she so chooses to intervene.
Okay, thank you, Chair Leach. Mr. Speaker,
Mr. Martinez-Fisher, for what purpose?
pursuant to relate Section 1A1, I raise a point of order.
Please bring your point of order down front. The point of order is withdrawn. The following amendment, the clerk will read the amendment.
Amendment by Leach.
Chair recognizes Mr. Leach to explain his amendment.
Thank you, Mr. Speaker. Members, this amendment proposes some technical refinements that clarify the disclosure requirements for proxy advisory firms who put their social interests ahead of the financial interests of shareholders. It does this very succinctly by clarifying, one, the disclosure required, including that the disclosure requirements apply to recommendations concerning director nominations, and secondly and finally, that it applies to companies reincorporating to Texas as well as those already here to prevent pre-incorporation penalizing actions. With that, I move adoption of the amendment.
Mr. Leach sends up an amendment. It is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Mr. Leach voting aye. Ms. Fairley voting aye. Show Mr. Wilson voting aye. Show Mr. Little voting aye. Show Ms. Schaffner voting aye. Mr. Anchia voting nay. Have all members voted? Have all members voted? There being 115 ayes, 11 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Capriglione.
Chair recognizes Mr. Capriglione to explain his amendment.
Thank you. Members, this is a simple amendment that clarifies that small nonprofits that happen to do research and stock advice are not impacted by this bill. I move adoption.
Members, Mr. Capriglione sends up an amendment. It is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Mr. Little voting aye, Mr. Leach voting aye, Mr. Capriglione voting aye, Ms. Isaac voting nay, Mr. Lozano voting aye, Mr. Anchia voting aye. Have all members voted? Show Mr. Curry voting aye. Have all members voted? Show Mr. Harris voting aye. Have all members voted? There being 92 ayes, 38 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Mr. Speaker,
Mr. Bernal, for what purpose?
parliamentary inquiry.
State your inquiry.
I believe that earlier in the day you had mentioned that you would look around the floor to make sure that people could see the amendments.
Yes.
And we literally cycled a pretty significant one through in less than a minute. And nobody wants to be unreasonable, but if we could just get an extra 30 seconds to see it, and if you or anyone else there could look for us, that would be very helpful.
We will certainly endeavor to do that, Mr. Bernal.
Thank you.
Thank you.
Amendment by Goodwin.
The chair recognizes Ms. Goodwin to explain her amendment.
Thank you, Mr. Speaker. Members, this amendment would ensure that proxy advisors that offer specialty or custom voting policies that align with Texas's anti-ESG stance are not unfairly burdened or punished by this law, while preserving the disclosure requirements for proxy advisors that do not adapt to varied views on ESG. Recently, Texas investment funds, including the Permanent School Fund, have adopted updated custom or specialty policies in light of recent pressure from the legislature to remove ESG factors from voting policies implemented by proxy advisors on behalf of these pensions. This includes the Permanent School Fund, which in April 2024 adopted an ESG skeptical proxy voting policy. The implementation of and recommendations in line with these anti-ESG policies by a proxy advisor on behalf of a state pension or the Permanent School Fund may differ from the implementation of other different policies chosen by other investors. This law then would perversely exact significant disclosure and reporting requirements on proxy advisors who are implementing the very type of policies that align with the state of Texas's views on ESG issues. The burdens created by Senate Bill 2337 are extensive. Under a broad array of circumstances, including making recommendations that do not align with board recommendations, providing different recommendations to different investors based on their differing voting policies, or providing recommendations based upon shareholders' decisions to prioritize ESG factors, proxy advisors are required to provide extensive disclosure requirements backed by onerous legal liability. Disclosure in and of itself is not always an issue. In this case, however, the disclosure requirements are administratively burdensome in terms of the quantity of disclosures required by the law and the vagueness of the requirements. With respect to vagueness, the bill requires notice, which requires an explanation of the recommendation, a written economic analysis, which analyzes the short and long-term economic benefits and costs of the shareholder proposal, and an analysis of whether the policy is consistent with the investment policy of the client. Piled on top of these extensive and vague requirements, failure to adequately comply with these requirements triggers extensive liability provisions under the DTPA and Texas AG enforcement. In creating these disclosure requirements and potentially subjecting such cooperative proxy advisors to significant civil penalties, we are providing a disincentive for proxy advisors to assist the state of Texas and do so by implementing anti-ESG policies. We should not disincentivize such customer, Texas-centric service. And with that, I move adoption.
The chair recognizes Mr. Leach to speak against the amendment.
Mr. Speaker, members, this guts the bill, and I am going to move to table right now.
The chair recognizes Ms. Goodwin to close on her amendment.
Members, this bill could do a lot of harm, and I know it's a very complicated topic, but I hope that you will vote with me for this amendment. Thank you. Move adoption.
Members, Ms. Goodwin sends up an amendment. Mr. Leach moves to table. Vote aye if you oppose the amendment. Vote nay if you support the amendment. The clerk will ring the bell. Show Mr. Leach voting aye, Mr. Hunter voting aye, Ms. Goodwin voting nay. Have all members voted? Show Mr. Verdell voting nay. Show Mr. Anchia voting nay. Have all members voted? Show Mr. Verdell voting aye now. Have all members voted? Have all members voted? There being 87 ayes, 52 nays, the motion to table prevails. Anyone wishing to speak on, for, or against Senate Bill 2237? Ms. Gervin Hawkins, for what purpose?
Will the gentleman yield for questions?
The gentleman doesn't have the floor at this time. We'll come right back.
Oh.
The chair recognizes Ms. Morales to speak against the bill.
What all this shit mean?
There we go. Thank you, Mr. Speaker and members. I respectfully oppose Senate Bill 2337 for the message that it sends. It threatens the values of fairness, transparency, and inclusion in the way that we govern investments and corporate behavior in this state. This bill is a direct attack on diversity, equity, and inclusion. It targets proxy advisory firms, those who guide investors on how to vote their shares, by penalizing them if their recommendations consider anything beyond just the financial returns. So that means if they dare to factor in how a company treats its workers, its environmental footprint, or whether its leadership reflects the diversity of this great state, they would face unnecessary scrutiny and bureaucratic roadblocks. So let's be clear. This bill tells investors they should not care about ethics or equity or the long-term sustainability of their investments, only short-term dollars and cents. And we know that's not how strong businesses or strong communities are built. I think about my friend from Houston, Gilbert Garcia, a proud Houstonian and the managing partner of one of the largest Latino-owned investment firms in the country. Gilbert has always made a point to run a diverse and inclusive office, not just because it's the right thing to do, but because it makes his firm better. More perspectives at the table mean better decisions. That's not ideology, that's sound business. Under this bill, a firm like Gilbert's, the one that believes diversity is an asset, not a liability, could be punished simply for aligning its investment advice with its values. And let me ask you this, who benefits from this bill? It's not retirees whose pensions are being managed. It's not long-term investors. The only people who win are those who want to silence dissent and insulate corporations from accountability. We're sending a dangerous message with this bill that Texans don't value diversity, that will protect corporations instead, no matter how they behave, as long as the money flows, that we don't trust investors to think for themselves. Members, we should be encouraging ethical investment practices, not censoring them. We should be lifting up leaders like Gilbert Garcia, not undermining their values. We should remember, business can be a force for good if we let it. I urge you to vote no on SB 2337. Let's stand up for inclusive values, for smart investing, and for a Texas that reflects all of us. Thank you.
The chair recognizes Mr. Curry to speak in favor of the bill.
So with all due respect to Ms. Morales, I disagree 100%. I'm 1,000% for this bill. This bill is designed to protect the small shareholders, to make sure that you understand as a shareholder that you may be caught up in a billion-dollar, multi-billion-dollar fight and you may only own 100 shares. And no different than in a lawsuit, if you were dealing with this situation and you had to hire a lawyer and you found out that that lawyer worked for the other side, that's a conflict of interest and a serious one. So you don't want that conflict of interest. You want, if they're going to have one, then they need to tell you, and they need to tell you what that conflict of interest is. So I will tell you, having been involved in these kind of companies as CEO of publicly traded companies, I will tell you that this is a very necessary law. It protects the shareholders, it protects the public, and it will protect every one of your constituents. I appreciate the bill. I'm for it.
The chair recognizes Mr. Leach to close.
Thank you,
Mr. Chair.
Ms. Gervin Hawkins, for what purpose?
Speaker, will the gentleman yield?
Gentleman yield for questions. Gentleman yields.
Yes.
Representative Leach,
Yes, ma'am.
because I want to be clear, because with the stock market potentially coming to Texas, we want to get more and more people investing.
No, it's not potentially coming. It's here.
Okay, it ain't here yet, but it's coming. All right. I want to be able to fully understand what you're trying to accomplish here. It appears to be a disclosure of conflicts of interest.
Correct.
And like Representative Curry indicated, that two lawyers or a lawyer represent you and the other side, that needs to be disclosed, correct?
Correct.
And I think that's a good thing. What I'm confused about and trying to wrap my head around is when we bring in DEI about this. What were you trying to accomplish in even mentioning that?
Well, Representative Gervin Hawkins, the point here is to make sure that proxy advisory firms, when they're rendering advice to one company or another and to their shareholders, that they're focused on economic factors, their fulfilling their fiduciary duties to their clients. And so when they're focused on non-economic factors, whether it's ESG, whether it's DEI, whether it's anything political or partisan or anything that's not non-economic, that's just one example of many, that would be that's what we want to prevent. That's what we want to avoid. That's what we want these proxy firms to have to disclose.
So the proxy member would then say, I hired this person because of?
Sure.
And who would they report that to? The person that they're representing?
Yes.
And so, you know, walk with me on understanding this. So, if I was to hire a proxy, or that proxy was selected through an investment firm, let's say, right? Then that investment firm would then have to say, well, Ms. Hawkins, we hired these people based on this criteria.
Wouldn't you want to know that?
Well, let me ask the question, sir. I'm trying to get it. Okay?
Yeah, and my answer is the answer to your question is yes, because I think that in your situation there, Representative Gervin Hawkins, you would not only want to know that, but under the force of law, you deserve to know that.
Well, if they are a good investor and they have a great history,
Then
I
they're
don't give a who
focused-
shot John if they black, brown, yellow, or green. That's why I'm trying to understand the purpose of this.
You're making my point for me. You should have come and laid out the bill for me. Because those factors should not matter when it comes to fulfilling your fiduciary duties to a company and its shareholders. You are making my point for me, and I appreciate you doing
that's why I'm wondering, why is it in here if it doesn't matter? Because we can assume...
It does matter. You just made the point that it shouldn't matter.
Can I ask the question, sir?
Sure.
Because what we're saying is... What I'm saying is, why is that piece, their demographics of ethnicity, why wouldn't their success rate be my greatest interest?
You're a shareholder in a company, Representative Gervin Hawkins. You've hired a proxy advisory firm to advise your shareholders on a vote, one way or another. If that vote is focused on any non-economic factors that are outside of their fiduciary duties to you as a shareholder, you deserve to know that. You deserve to know if they are giving you one piece of advice to invest here, to vote this way, and then giving another company another piece of advice to not invest there. That's not good. You deserve to know that, whether it's a lawyer that's telling one client one thing and telling the other party another thing, or a lobbyist in this building who's hired to advocate for a piece of legislation and is also being paid to oppose the piece of legislation. These are irreconcilable conflicts of interest that, under the force of law and under the weight of this bill, if passed and signed by the governor, deserve to be disclosed to the people who are depending on those proxy advisory firms to fulfill their fiduciary duties to the shareholders.
I get that, but what you're not explaining to me is, where does diversity, equity, and inclusion? So, as an example, would I say this firm was hired because they were 100% women? Would I say this firm was hired because they're 100% African American? I'm not understanding
That's
the
not
connection.
I don't think, with all due respect, Representative Gervin Hawkins, you are brilliant and wise and one of the smartest members on this floor, and I'm not meaning to say that you're I don't think you have the requisite knowledge with respect to what proxy advisory firms are doing. They are not involved in the discussions and the decisions that you just mentioned. They are hired to advise shareholders and their proxies on votes. They are hired to fulfill fiduciary duties to the shareholders, not to deal with the situations that you are outlining. I think you're confusing the intent and the objective of the bill.
Let me be clear on my question, though, okay? Maybe I'm not clear on my question. I get that on the proxy advisors, but you're saying as a shareholder, I need to know why this proxy advisor was selected? Is that what you're saying?
You deserve to know, Representative Gervin Hawkins. I don't know any other way to put it any more plainly. If you are a shareholder, you deserve to know if your proxy advisory firm is advising you to vote one way or another company one way based on any factor that is non-economic, whether it's ESG or DEI or anything else. You deserve to know that. That should be disclosed to you, and that's what this bill does.
Thank you for answering my question.
You're welcome, and I meant what I said. With that, Mr. Speaker, I move final passage.
Members, the question occurs on passage to third reading of Senate Bill 2337. This is a record vote. The clerk will ring the bell. Show Mr. Hunter voting aye, Mr. Curry voting aye, Ms. Plesa voting nay, Mr. Reynolds voting nay, Mr. Manuel voting nay, Mr. Scofa voting aye. Have all members voted? Have all members voted? There being 92 ayes, 47 nays, Senate Bill 2337 passes to third reading. The chair lays out Senate Bill 1610 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 1610 by Perry, relating to sexually violent predators to the Texas Civil Commitment Office and to the prosecution of the offense of harassment by sexually violent predators and other persons confined in certain facilities, amending and harmonizing certain statutes of limitation provisions, amending certain sex offender registration requirements, changing the eligibility for community supervision, parole, and mandatory supervision for sexually violent predators, creating a criminal offense, increasing criminal penalties.
The chair recognizes Mr. Cook.
Thank you, Mr. Speaker. Members, this is a long bill, and so I will try to be brief and get through it quickly, but also wanted to spend just a little bit of time on it. So with regard to the background and purpose of this bill, the Texas Civil Commitment Office provides treatment and supervision to their clients who have been civilly committed as sexually violent predators. The TCCO, as it's known, is continued to encounter several challenges with problematic clients that regularly hinder the effectiveness of TCCO's treatment and supervision programs. There are several parts within the bill that deal with safety and security, the sex offender registration, criminal history and court proceedings, the governing statutes with regard to TCCO, the procurement basis for the TCCO, the civil commitment statutes, and lastly, the sentencing and three-strike rule. In conclusion, I would just like to say that members, we need to take the important steps to end rape, as Ms. Thompson talked about earlier, is getting rid of the pimps, and we need to get rid of rape in Texas. And by arming the Texas Civil Commitment Office with the tools that they need, we can do just that. Members, I'm asking you on behalf of all rape victims in the state of Texas and throughout to please help pass this critical public safety bill. And there are a few amendments.
The following amendment, the clerk will read the amendment.
Amendment by Cook.
The chair recognizes Mr. Cook to explain the amendment.
Thank you, Mr. Speaker. Members, this amendment was requested by the Comptroller's Office and is simply to narrow the scope of the procurement authority that's granted to TCCO office with regard to office supplies, building maintenance, and temporary employment services. It's acceptable to the offer, and I move adoption.
Mr. Cook sends up an amendment. It is acceptable to the author. A record vote has been requested. The clerk will ring the bell. Show Ms. Schaffner voting aye. Ms. Weiner voting aye. Show Mr. DeRazio voting aye. Show Mr. Cook voting aye. Have all members voted? Have all members voted? There being 139 ayes, 0 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by Weiner.
The chair recognizes Ms. Weiner to explain her amendment.
Thank you, Mr. Speaker, members. Civil commitment facilities are a tough topic, and I really applaud Representative Cook and Senator Perry for taking the issue on. That said, I think this bill has a couple missteps that we can correct. And the biggest is that it makes it a third-degree felony for a resident of a civil commitment center to be in possession of nicotine products or alcohol. So members, my amendment is very simple. It strikes that language. Civil commitment centers, I will remind you all, are by definition not to be treated as prisons. Civil commitment center residents have already served their sentence for their crimes. However, under the bill's current language, the possession of nicotine products or alcohol within a civil commitment center would be treated as a third-degree felony, punishable by 2 to 10 years in a TDCJ facility, and a fine of up to $10,000. However, this bill goes a step further. This bill also establishes that if a resident of a civil commitment center is found guilty of a felony offense other than a state jail felony, that individual is subject to 25 to 99 years of imprisonment. Members, ask yourselves, is it reasonable to impose up to life imprisonment for the unlawful possession of cigarettes or chew by adults that, as far as the law is concerned, are not prisoners? Members, I will remind you, our prisons are already overcrowded, driving us to export our prison population to other states. We do not need to be growing our prison population for the possession of tobacco products. I urge you to vote in favor of this amendment. I move adoption.
The chair recognizes Mr. Cook to speak against the amendment.
Thank you, Mr. Speaker. Members, with regard to this amendment, Senator Perry and Flores has asked that I not accept this amendment, and that's what I'm going to do, and I'm going to ask that you vote no on this amendment.
The chair recognizes Mrs. Weiner to close.
Thank you, Mr. Speaker. Members, I just want to go back to some fairly recent history. Just 10 years ago, lawmakers raised serious constitutional concerns about the civil commitment system when they discovered that no one had ever been released from the program and that approximately half of the participants had been reincarcerated in TDCJ for technical rule violations. So in 2015, we overhauled the program, putting these draconian penalties on tobacco and alcohol possession is going the other way and is going to take people from this program and put them back into our prisons, which is not the goal of a program that is designed to be therapeutic. So members, I urge you to vote yes for this amendment. Please support reasonable penalties. I move adoption.
Ms. Weiner sends up an amendment. The amendment is not acceptable to the author. All those in favor of the amendment say aye. All opposed? A record vote has been requested. The clerk will ring the bell. Show Mr. Cook voting nay, Ms. Howard voting aye, Ms. Troxler voting nay. Have all members voted? Have all members voted? There being 59 ayes and 82 nays, the amendment is not adopted. The following amendment, the clerk will read the amendment.
Amendment by Troxler.
I'll give you a moment. The chair recognizes Ms. Troxler to explain her amendment.
This amendment was brought to me by a DA in my district who is having issues prosecuting non-consensual sexual assault. In short, this amendment just refers to the definition of consent as defined by section 1.07a in order to give our local prosecutors the tools that they need to bring perpetrators to justice and to protect victims. And I move adoption.
Ms. Troxler sends up an amendment. The amendment is... Chair recognizes Mr. Cook to speak on the amendment.
Thank you, Mr. Speaker. Thank you, Mr. Speaker. Members, same here with regard to this particular amendment. Senator Perry's office has asked that we not agree to this proposed amendment. I'm going to leave it to the will of the body. I will say that I believe that this body here has dealt with the consent issue with several different bills throughout the session. I agree with the intent with what Representative Troxler is trying to do and agree, quite frankly, with what her district attorney is telling her. But out of respect for the bill author, again, I'm speaking on, and I will leave it to you to decide how to
Speaker?
vote.
Ms. Howard, for what purpose?
Yes, with the gentleman.
Gentleman yield for questions.
I will.
Gentleman yields.
Thank you. I do appreciate what this body has done in terms of making a clear and strong statement that we need to define consent so that we can put these heinous people behind bars who are actually assaulting women. And we have been told by prosecutors that they need this tool in order to prosecute these folks. Right now, consent has been a big barrier to ensuring that when people come forward and say that they've been assaulted, the prosecutors do not have the tools to put them away because we do not have a definition of consent. We have tried to do that in the House. And I appreciate that Representative Trosclair is adding into that, making sure that we get clear definitions here. That will help us to make sure that we have the tools we need to prosecute those who commit these heinous crimes. And I hope that the body will support this amendment. Thank you.
The chair recognizes Ms. Troxclair to close.
Thank you, Mr. Speaker, and thank you to Representative Howard for all of your work on this issue and for protecting women across this state. This amendment has also been run past the governor's office, who has done a lot of work to protect women as well, and approved by them. So a vote for this amendment is a vote to protect women. A vote against this amendment is a vote to protect the people who sexually assault them. I move adoption.
Members, the question occurs on the adoption of the amendment. All those in favor vote aye. All of those opposed vote nay. Division vote. A record vote has been requested. The clerk will ring the bell. Show Ms. Troxclair voting aye, Ms. Zwiener voting aye, Ms. Howard voting aye, Ms. Plesa voting nay, Mr. Anchia voting aye. Have all members voted? Have all members voted? There being 99 ayes and 31 nays, the amendment is adopted. Ms. Plesa, for what purpose?
I have a question for the author of this bill.
Let me recognize the author. Anyone wishing to speak on for or against? Chair
The author of the bill.
Chair recognizes Mr. Cook to close on the bill. Land the plane. Ms. Plesa, for what purpose?
Does the representative yield for some questions?
Gentleman, yield for questions.
I do.
Gentleman yields.
Representative Cook, I just had a question. The Troxclair Amendment, was that approved by TCC?
I have not spoken with TCC, no.
Okay, thank you so much.
You bet. I'm moving.
Mr. Speaker.
Mr. Bryant, for what purpose?
Well, gentleman, yield for a question.
Gentleman, yield for questions.
Yes, sir.
Gentleman
Mr.
yields.
Cook, we heard the dialogue between you and Ms. Weiner earlier, and she described the bill as,
That's
with
not before the
the
body.
language that you have put into it, as
It's not before the body.
providing that a person who's been committed but who's been caught in possession of nicotine products.
Yeah, this matter is not before the body. I'm happy to answer any questions about the bill, but that's not before the body.
I'm sorry, it's in your bill. I'm asking you if it's in your bill.
Well, you keep referring to Mrs. Weiner's amendment, and
I said in the course of that debate, she described your bill as containing a provision which said that a person found in possession of nicotine who is civilly committed, not in the criminal system, but civilly committed, which is what your bill deals with. That
as a serial rapist, civilly committed as a serial rapist, yes.
But no longer in the criminal system, civilly committed. Isn't
After
that
they've
correct?
committed multiple rapes, yes. That's the person we're talking about.
Yeah. Well, okay, if you want to split hairs here about all that.
I'm not splitting hairs. I just want to
Yeah.
make sure the body fully understands. We're not talking about someone walking down the street and having nicotine. We're talking about someone that has been convicted
Okay, well,
of
fully
serial
explain it.
rapist and now is civilly incarcerated. Yes,
This
sir.
is a person that has been prosecuted, convicted, served their time, and is, as part of the statute provides, deemed in need of civil further treatment because it's not believed that they are rehabilitated.
Because they remain a danger to society. You're correct.
Right. And that kind of person who is in the civil commitment system now, as she described it, and I'm asking you to give me a yes or no.
Yes, sir.
Is it true that a person like that found in possession of nicotine products could get 25 years to life?
That's what's in the bill, yes.
Well, isn't that unreasonable? I mean,
Well,
for goodness sakes.
My guess is, that, like I answered the question from Ms. Plessa, was that I have not spoken with TCC, but my guess is because they're not legally entitled to have it, and because someone must have, secretly placed it into their possession. So that's the best guess that I have. But I have not spoken with TCC about that.
But if they're found to be in possession of it, they can be put in prison for 25 years to life. Nicotine products.
That's what the bill provides. Yes.
Thank you.
Move passage.
The question occurs on passage to third reading of Senate Bill 1610. A record vote has been requested. The clerk will ring the bell. Show Mr. Manuel voting nay. Manuel, nay. Show Ms. Morales of Harris voting nay. Have all members voted? Have all members voted? There being 85 ayes and 56 nays, Senate Bill 1610 passes to third reading. The chair recognizes Mr. Smithy for a motion.
Thank you, Mr. Speaker. I move to suspend House Rule 8, Section 5D for Senate Bill 1362 to designate the following members as joint sponsors: Patterson and Metcalf.
Members, you've heard the motion. Is there objection to the adoption of the motion? The chair is on the motion is adopted. Chair lays out on second reading Senate Bill 1362. The clerk will read the bill.
SB number 1362 by Hughes, relating to prohibiting the recognition, service, and enforcement of extreme risk protective orders, creating a criminal offense.
The chair recognizes Mr. Hefner.
Thank you, Mr. Speaker. Members, Senate Bill 1362, known as the Anti-Red Flag Act, safeguards Texas constitutional rights by banning the recognition or enforcement of red flag orders, also called extreme risk protective orders, in Texas. It reinforces Texas' commitment to protecting the rights of law-abiding citizens while ensuring due process for all Texans.
Mr. Speaker?
Mr. Verdell, for what purpose?
Will the gentleman yield for a couple
Gentleman,
of
yield for questions.
Let me read one more paragraph.
Not at this
then
time.
I'll be happy to answer your questions. The Anti-Red Flag Act prevents all governmental entities in Texas from recognizing or enforcing red flag orders unless explicitly authorized by Texas law. Furthermore, the bill prohibits Texas entities from accepting federal funds to enforce red flag laws in the state, and I'll be happy to answer questions.
Mr. Verdell, for what purpose?
Will the gentleman be happy to answer questions?
Gentleman yields for questions.
Yes,
Gentleman
I
yields.
yield.
Thank you, Representative Hefner. Are you familiar with the Fourth Amendment? I assume we all are, since we're legislators here. I'd like to just read a part of it real quick, which is the right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And this is the important part. And no warrant shall issue but upon probable cause, support by oath or affirmation, and particularly describing the place to be searched and persons of things to be or things to be seized. Are you aware that other states have been in violation of this and without due process have been confiscating citizens' firearms?
I don't know any specifics, but I do know I've heard stories of the violation of those due process rights.
I do actually have a story in here. I'm trying to be really quick because I know everybody wants to get to the bills that we need to. So one of the things that's interesting is, what state was that? I've got it right here. In Maryland, where red flag law had been passed, 61-year-old Gary Willis was in his home, and cops at 5 in the morning had, which based on no actual evidence or due process, showed up at 5 in the morning to confiscate his firearms. And that unfortunately ended with an honest man having those firearms, or him killed in that. Or have you heard something like that before?
I've heard stories like that, yes, sir.
And then there was a study done by the RAND Corporation that said that based on the states that have enacted red flag laws, they have not actually seen any reduction in crime from these red flag law implementations.
Yeah, I'll take your word for that, yeah.
And then just a couple more, and I'm almost done because I know we got other people behind me. Have you seen, would you be okay if you were not informed and no due process happened, but a committee of people had met without you knowing, without any representation, and them deciding that you might be a threat to society, and so they're going to take your firearms from you without following the Fourth Amendment? Would you be okay with that?
No, I would say that was turning due process upside down completely.
Yes, sir. It sounds a lot like the Minority Report, if you remember that movie, where innocent people were being basically captured without any threat. So I know I got people behind me. I'm going to step out of the way for a minute, but I appreciate you. And I also want to say thank you very much for all the work you've put into your committee and bringing these bills forward, such as this bill here. Appreciate that. Thank you.
Mr. Speaker?
Ms. Weiner, for what purpose?
I raise a point of order under Rule 32, Rule 4, Section 32C1, that the background and purpose is substantially and materially misleading.
Please bring your point of order down front. Mr. Harris on the floor of the House.
The point of order has been withdrawn.
Mr. Speaker,
Zwiener, for what purpose?
I raise a point of order against further consideration of SB 1362 under Rule 4, Section 32C2, that the bill analysis is substantially materially misleading.
Bring your point of order down front.
The point of order is withdrawn.
Mr. Hefner to continue laying out his bill.
I have an amendment.
Following amendment. Following amendment, clerk will read the amendment.
Amendment by Bryant.
Chair recognizes Mr. Bryant.
Thank you, Mr. Speaker and members. An extreme risk protection order is an order sometimes associated with the term red flag laws, which are and have been for some time a means much advocated by people that take a reasonable approach to the use and possession of firearms to try to interdict a situation where people are at risk of harming themselves and others. It's very much like a domestic violence protection order. Indications in other states are that 2/3 of them are issued due to risk of suicide. And indications are in Connecticut and in Indiana that stronger enforcement through these extreme risk protection orders resulted in suicides dropping significantly in measurable percentages in both cases. For reasons that are very difficult to understand, this bill attempts to stop the enforcement of extreme risk protection orders issued by other states because Texas has no provision for extreme risk protection orders. No matter how much a person indicates a propensity and perhaps a growing propensity toward the use of firearms to carry out suicide or mass violence, no matter what the indications, we have no provision for interdicting that behavior and separating that person from their gun. We don't have that in Texas. So one would ask, well, then why do we have this bill before us? It's just another bill to try to flex our pro-gun muscles to make it look like we're doing something. What they're trying to do is to say it's going to be a crime for any one of our public officials to enforce a protective order issued to stop somebody who's close to suicide or close to a mass shooting, even if that order has been issued by another state. So New Mexico, which has extreme risk protection orders, could issue one against somebody who is threatening mass shootings, and that person could leave and drive 30 miles south into El Paso, and no one would recognize that order, buy a gun and carry out exactly the atrocity that he was prevented from carrying out in New Mexico. This is what's known as a bad old bill. It doesn't have any purpose. I'm really surprised that the majority wants to block up the calendar with this kind of legislation when more substantive bills are coming after it. The amendment that I've offered is an amendment to strike everything below the enacting clause and kill this bad old bill and move on to something that is substantive.
Mr. Speaker.
Mr. Reynolds, for what purpose?
Would the gentleman yield for some questions?
Gentleman yield for questions. He yields for questions.
Thank you, Mr. Speaker. Representative Bryant, you talked about how red flag laws help reduce suicide. Is that correct?
Yes.
And it's my understanding from some research that red flag laws allow for the temporary removal of firearms from individuals deemed a significant risk to themselves, particularly in cases of suicidal ideation or behavior. Is that correct?
That is correct.
And are you aware that there is actually research that shows that there is a statistically significant decrease in firearm-related suicides in states with red flag laws. Are you aware of that?
I'm aware of that. A reduction in suicide rates consistently shown up in the studies in those states.
So if we want to reduce suicides, then this is a step in the right direction. This is a guardrail or a tool in the toolbox to help reduce suicides. Is that not correct, Representative Bryant?
It would be if we could pass one, but we don't have one in Texas.
Are you also aware that red flag laws have been proven to help reduce the number of mass shootings?
Yes.
And so we know that just a few days ago, unfortunately, we had the anniversary of the shooting at Robb Elementary School in Uvalde, correct?
Correct.
Wouldn't you think that we as a state, even if we didn't pass the law to raise the age to purchase assault rifles, which I think you and I would believe that we should raise the age to 21, at least we could do was implement red flag laws after that tragedy. Would you agree with that?
I would certainly think it's almost inconceivable that we have not already done that. That kind of a law could have prevented the shooting in Uvalde.
Are you also aware, Representative Bryant, that an overwhelming majority from research that I've seen that law enforcement supports red flag laws?
Yes.
Do you believe that red flag laws infringe upon anyone's constitutional Second Amendment right to bear arms?
They don't infringe upon that right any more than they infringe upon a person's rights when you have to have a domestic violence related protective order or a mental health related protective order. It's just part of life, part of society. There should be no special treatment for guns.
Are you also aware that polls, meaning that there have been numerous polls that suggest broad public support for red flag laws, even among Republican gun owners?
That's correct.
And basically, we've stated so many compelling reasons that don't limit people's constitutional right to bear arms, that help reduce suicides, that help reduce mass shootings, that help keep guns out of people that could pose a harm to themselves or others. So why do you think that we are even debating not having red flag laws?
I don't know, particularly when the University of Houston's Hobby School of Public Affairs indicates that 88% of Texans, including 81% of Republicans, support extreme risk protective orders. This bill, which I'm hoping that we don't pass, would, before we ever get extreme risk protective orders, make it a crime to enforce them if they're issued in other states.
Representative Bryant, do you believe that one of the reasons could be that there is an over-reliance upon scorecards from the National Rifle Association?
No question about it.
And do you believe that we should put the interests of public safety in Texans before the special interests of profits in selling more guns and ammunition?
I certainly do, and I believe that we ought to take a holistic look at our country and our state and what our people need and be reasonable about it. I'm a gun owner. When I finish hunting, I put my guns in the closet. I don't spend all day long thinking about them or laying awake at night daydreaming about being a hero using those guns. I put them away. They're there if I need them for protection of my household or if I want to go hunting. This unreasonable approach to guns is causing mass murders and causing suicides.
Well, Representative Bryant, are you also aware that because they couldn't get comprehensive federal gun reform legislation passed, former President Biden did take a step in the right direction and utilized an executive order for red flag laws? Are you aware of that?
I'm aware of that.
And don't you believe that we as a state have a fiduciary responsibility to our constituents to do everything that we can to reduce the epidemic of gun violence in this state.
I do.
And red flag laws are certainly one of the tools in the toolbox that we could use, including raise the age, closing the gun show loophole. Are you aware of that?
I totally agree with that.
I think you have an excellent amendment. Thank you, Representative
Thank
Bryant.
you. This amendment would strike everything below the enacting clause and kill this bill. I urge you to vote for the amendment.
Mr. Hefner in opposition.
Thank you, Mr. Speaker. Members, this strikes the enacting clause, so I'm going to ask you to vote this amendment down, straight up or down. Vote no.
Mr. Bryant.
Vote aye for what's reasonable. Let's move on. Let's get on down the calendar. Otherwise, we're going to be here a long time.
Question occurs on the Bryant amendment. It's a record vote. Clerk, ring the bell. Mr. Kane voting no. Mr. Hefner voting no. Mr. Hunter voting no. Mr. Metcalf voting no. Ms. Morales voting aye. Ms. Goodwin voting aye. Have all members voted? Ms. Kerwin voting no. Have all members voted? 56 ayes, 87 nays. The amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Hefner.
Mr. Hefner.
Thank you, Mr. Speaker. Members, this amendment I filed myself. It basically just clarifies that we're not doing something that we're not doing in the bill. I worked on this with the gun groups to make sure they were at least neutral with it. And so I ask you to vote with me, vote yes on this amendment to adopt it. Move adoption.
Mr. Hefner sends up amendment. It's a record vote. Clerk, ring the bell. Mr. Hefner voting aye. Patterson voting aye. Kane voting aye. Ms. Goodwin voting aye. Have all members voted? Have all members voted? 119 ayes, 16 nays. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Goodwin.
Ms. Goodwin.
Thank you, Mr. Speaker. Members, this amendment is about the provision in the bill that would take away federal grants. So federal grant funds are proven life-saving programs. Many federal grants support violence prevention, crisis intervention, and mental health services. The very programs that help communities reduce gun deaths and save lives. Refusing these funds limits Texas's ability to implement programs that are working across the country. Turning away funds harms local communities. Cities and counties, especially those hit hardest by gun violence, like parts of Houston, Dallas, and El Paso, rely on federal dollars to support community-based safety efforts. Prohibiting access to these grants takes tools and resources away from local governments and law enforcement. This would be fiscally irresponsible. Texas taxpayers already pay into the federal system. Refusing these grants means Texas funds programs in other states while getting nothing in return. That's not just harmful, it's fiscally wasteful. Local control should be respected. By denying the acceptance of federal grants, SB 1362 strips local jurisdictions of the right to decide what's best for their communities. Cities and counties should be able to access available resources to keep their residents safe without interference from state lawmakers imposing one-size-fits-all mandates. Blocking grants undermines public safety innovation. Federal grants help pilot innovative, evidence-based solutions from hospital violence intervention programs to community outreach teams. SB 1362's rejection of these funds stops Texas from participating in nationwide progress on gun violence prevention. This provision is politically motivated, not publicly supported. Most Texans across political lines, as you just heard Representative Bryant say, want practical, common sense safety solutions not political grandstanding that blocks help. Stripping this provision focuses SB 1362 on real public safety concerns, not ideology. Removing the grant ban protects the most vulnerable. Communities of color, low-income neighborhoods, and areas with high gun death rates are often the intended beneficiaries of these federal grants. Cutting off funding to these areas perpetuates inequality and undermines statewide safety goals. With that, I move adoption.
Mr. Hefner.
Thank you, Mr. Speaker. Members, we worked on this bill for a while. We took the amendment that we believe gets the bill where it should be for the Senate to concur, and I ask you to vote with me to oppose this amendment.
It's a good one to close.
Members, by his argument, we should never change bills that come before us through the debates that we have back and forth when we think of things that might strengthen the bill or things that might make a bill better because they've already been heavily negotiated. That's what we're doing here right now, is looking at these bills and figuring out what makes sense for our communities and the state of Texas. And by saying that we're not going to take federal dollars, these federal grants that, again, help our hospitals with violence intervention programs is just not smart. So please vote with me to adopt this amendment.
Record vote on the Goodwin amendment. Clerk, ring the bell. Show Mr. Hefner voting no, Ms. Goodwin voting aye, Mr. Hunter voting no. Have all members voted? Have all members voted? 59 ayes, 84 nays. The amendment fails to adopt. Following amendment, the clerk will read the amendment.
Amendment by Goodwin.
Ms. Goodwin.
Thank you, Mr. Speaker, members. This particular amendment is regarding law enforcement initiated extreme risk protection orders. So my amendment exempts the extreme risk protection orders initiated by law enforcement officers. Notwithstanding any provision of the Act, nothing herein shall be construed to prohibit a peace officer, law enforcement agency, or prosecuting attorney from petitioning a court of competent jurisdiction for a temporary extreme risk protection order to prevent an individual from accessing firearms, provided that the petitioner presents clear and convincing evidence. And members, I'm reading this because this will tell you what an extreme risk protection order does. Now, granted, we don't have extreme risk protection order in law in Texas, but we do have protection orders. And so that you can understand what the difference is, the individual, again, would be prevented from accessing a firearm provided that, first of all, the petitioner presents clear and convincing evidence that the individual poses an imminent risk of harm to themselves or others. And again, members, this would go through due process. Oftentimes, the argument against extreme risk protective orders is that there is no due process, and that's simply not the case. So a petitioner would be going before a judge. Second of all, the petitioner includes sworn affidavits, incident reports, or other supporting documentation. 3, the court holds a hearing within 14 days of the issuance of a temporary order. Again, members, this is due process. This is going before a judge in a court. Number 4, the individual subject to the order has the right to counsel and to contest the order at the hearing. Members, what is this? It is due process. 5, any final order shall be limited in duration to no more than 6 months, subject to renewal upon further judicial review. Okay, did y'all hear that? It's not taking someone's gun away permanently. Says this order would be limited in duration to no more than 6 months. And finally, firearms surrendered under such an order shall be returned promptly upon expiration or termination of the order. Members, we should certainly be doing everything that we can to make sure our communities are safer. When you hear the argument that red flag laws don't allow for due process, that is simply false. I have just read you what the steps would be for an extreme risk protective order. With that, I move adoption.
Mr. Reynolds, for what purpose?
Would the gentlelady yield for a question?
Gentlelady for questions?
Yes, I will.
Shields for questions.
Representative Goodwin, I was listening to your amendment layout. I can tell you that last session I had a similar bill that was brought to me by my district attorney from Fort Bend County, Brian Middleton. Are you aware that there are district attorneys that believe that your amendment would be helpful?
Oh, absolutely. I think all across Texas they would agree with that.
And are you aware that based on the bill author's argument that we don't want to take away due process, your amendment gives due process, correct?
That's absolutely right. And like you, I have also filed bills in which we would be creating the framework for these types of orders so that we are giving people their due process and so that our district attorneys and our judges throughout the state would know how the process works.
And the long end of it is that this process is a temporary, potentially, removal of the gun from the hands of someone until they can make a determination, correct?
That's absolutely correct. And I think all of us can think of situations where this could have been helpful. It could have prevented deaths.
And I'm no psychiatrist or psychologist, but there are certain times that an individual may be in a manic episode, correct?
Yes.
And those individuals, we may have medical documentation, and therefore that information is presented that there's a compelling reason why the firearm should be temporarily removed, correct?
Absolutely.
And don't you believe that these are reasonable limitations to help potentially reduce a potential mass shooting?
Yes, I absolutely believe that. And that's why I and you and other members have worked so hard to put in place extreme risk protective orders here in the state. In fact, after the shooting in Uvalde, Representative Jerry Patterson, who, former Senator Jerry Patterson, former General Land Officer, Commissioner, was in one of the hearings that we held after Uvalde, and he actually suggested that we should pass an extreme risk protective order law here in Texas. And he is the one who I think was the original concealed carry bill author here in the legislature.
And Representative Goodwin, finally, in addition to district attorneys, I've also talked to law enforcement, because when I had this bill, I talked to law enforcement about extreme risk protective orders. And the law enforcement officers that I talked to, sheriff, constables, police officers, police chiefs, all of them have said that this is something that would help save lives, whether it's suicide, domestic violence, homicides. Are you aware of that?
Yes, you know, I believe in working with all the stakeholders, and that certainly includes our law enforcement. They're out there on the streets every day putting their own lives at risk. And when they see somebody that they say, wow, this person has given all the signs, all the indicators, the red flags that they are going to harm themselves or somebody else, and there's nothing they can do about it. It's incredibly frustrating, and it's putting their lives in jeopardy too.
And you just made my final point. So this is putting law enforcement's lives at risk as well as ordinary citizens. So basically, this is a pro-public safety amendment that you have filed. I think that is great. This is a common sense gun safety measure, and I hope that people will support your amendment. Thank you for filing it.
Thank you. You know, we always talk about backing the blue. Members, this would support our law enforcement and give them a tool in their tool belt to make sure people who are at risk of harming themselves or others, there's something that they can do about it. With that, I move adoption.
Mr. Hefner. Ms. Gonzalez sends up an amendment. It's a record vote. Clerk ring. Goodwin sends up an amendment. Record vote. Clerk ring the bell. Hefner voting no. Goodwin voting aye. Hunter voting no. Have all members voted? Have all members voted? Have all members voted? Bowers voting aye. Have all members voted? 56 ayes, 86 nays. The amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Goodwin.
Ms. Goodwin.
Thank you, Mr. Speaker. Members, thank you for bearing with me. I know I have a number of amendments to this bill because I am strongly opposed to limiting our options when it comes to extreme risk protective orders. So this particular amendment simply says that we should empower our local communities. This amendment gives cities and counties the flexibility to protect their residents from gun violence, especially in situations where an individual poses an imminent risk while respecting local control and community needs. This would save lives with due process intact. Extreme risk protective orders have been shown to prevent suicides and mass shootings. This amendment allows local governments to use this life-saving tool with full due process protections, notice, hearing, judicial review, and the right to counsel. This protects Second Amendment rights. This is not about gun confiscation. The amendment clearly prohibits permanent removal of firearms without a separate criminal or mental health adjudication. Temporary orders must be based on sworn evidence and reviewed in court. This amendment targets imminent threats, not lawful gun owners. Extreme risk protective orders are narrowly tailored to address urgent threats of harm, like someone experiencing a mental health crisis or making violent threats, not law-abiding citizens exercising their rights. Members, we've had many situations where someone who is close to someone who becomes a mass shooter has seen those signs. Again, we need local problems and local solutions. We need local solutions to local problems. Gun violence doesn't look the same in every community. Local officials are best positioned to know when, how, and whether to implement extreme risk protective orders. This amendment preserves their ability to respond responsibly. It doesn't mandate extreme risk protective orders. It only permits them. This amendment doesn't force any municipality or county to implement extreme risk protective orders. It simply removes barriers for those who choose to act, ensuring local autonomy within constitutional bounds. Extreme risk protective orders do have bipartisan support, States across the political spectrum, including Florida, Indiana, and California, have adopted extreme risk protective orders. They are a proven constitutional approach to preventing gun tragedies. I move adoption.
Chair recognizes Mr. Hefner to speak against the motion.
Thank you, Mr. Speaker. Members, this basically does exactly what we're trying to prevent with the bill, so I respectfully ask you to vote no on the amendment.
Ms. Goodwin sends up an amendment. The amendment is not acceptable. The record vote has been requested. The clerk will read the bill. Show Mr. Hefner voting nay, Ms. Goodwin voting aye. Ms. Gonzalez of Dallas voting aye. Show Mr. Hunter of Corpus Christi voting nay. Have all members voted? Have all members voted? There being 57 ayes, 83 nays, the amendment fails to adopt. Following amendment, the clerk will read the amendment.
Amendment by Goodwin.
The chair recognizes Ms. Goodwin to explain her amendment.
Members, this amendment makes the bill contingent upon raise the age legislation. Uvalde demands action, not symbolism. This amendment honors the lives lost at Robb Elementary by tying SB 1362's enactment to meaningful gun safety reform, specifically raising the legal age for purchasing semi-automatic rifles to 21. Anything less fails to meet the moment. Public safety must be the priority. The amendment ensures that SB 1362 does not move forward unless the legislature first addresses the clear and present danger posed by easy access to high-powered firearms by minors. This is a reasonable, targeted measure. The amendment includes narrowly tailored exceptions for military service members, law enforcement, and supervised youth involved in lawful hunting or shooting sports. This is not a blanket restriction. It's a balanced policy with public support. Broad public support for raising the age. Polls consistently show that a strong majority of Texans, including gun owners, support raising the minimum age to purchase assault-style weapons to 21. This amendment aligns with the will of the people.
Mr. Speaker,
Ms. Morales, for what purpose?
will the gentlelady yield for some
Lady yield
questions?
for questions.
Yes, I will.
Lady yields.
Representative Goodwin, I really appreciate your amendment. So basically what you're saying is that if we're going to pass this bill, it should be on the contingency that we raise the age to 21 to purchase assault-style weapons?
That's correct.
Because it has been 3 years since 19 children and 2 teachers were murdered at Robb Elementary. Is that correct?
That is correct. And, you know, the families of the victims of the Uvalde children and the 2 teachers came to the Capitol repeatedly last session, hoping that they would get a hearing, hoping that their bill would come to the floor. And then this session, I feel like the hope has run out for them. But I hope that if they are watching, they understand that there are many of us on this House floor who really want to do something to help them, and that would be to raise the age to buy semi-automatic weapons to 21.
Did you realize that the dad, Brett Cross, was here just the other day? I'll give it to you in just a minute.
Yes, I actually.
The dad, Brett Cross, was here just the other day, and he was out here. I'm sorry.
It's very loud, Mr. Speaker.
I'm talking. Mr. Speaker.
For what purpose?
I'm trying to speak, but
I have a privilege motion.
Generally yield for questions.
okay. Ms. Goodwin,
Generally yield for questions.
Mr. Speaker, does the gentlelady yield for questions?
Generally, she yields for
Okay.
questions.
Thank you. Representative Goodwin, are you aware that Brett Cross, the dad of Uzziah Garcia, was here?
Yes, I saw him in the lobby.
Yes, he continues to come here to the Capitol. And also, are you aware that the moms from Uvalde were also here? I ran into them in the hallway. Did you get to speak with them? They brought pictures of their children.
I don't think I saw them the same day, but I have seen them here in Austin. I know that with the Lives Robbed organization, they've actually been doing some community awareness programs, and so I have been able to see them.
I appreciate this amendment so much because those families continue to come here, drive 5 hours, and I know you've been with us when we drove last session to Uvalde to honor the anniversary, and it was really heartbreaking, and we haven't done anything to address the children and folks who continue to be victims of gun violence.
That's right. That's right. And it's heartbreaking. I can hear the emotion in your voice. It is very emotional. It's well past time. It's ironic that when there is a mass shooting, people will say this is not the time to try to talk about policy. And now that there hasn't been one within recent days, again, it doesn't seem to be the right time. When is the right time? When is the right time for Texas to really have some good gun safety, gun violence prevention legislation passed here in the state?
Ms. Goodwin, wouldn't you agree that raising the age to 21 isn't just about good policy, it's about decency?
That's right.
Thank you.
Thank you. I move adoption.
Mr. Hefner in opposition.
Thank you, Mr. Speaker. Members, I respectfully oppose this amendment. Please join me in voting no.
It's a good one to close.
Members, for the Uvalde families, please vote with me and accept this amendment. I move adoption.
Record vote on the Goodwin amendment. Clerk, ring the bell. So Mr. Hefner voting no, Ms. Gonzalez of Dallas voting aye, Ms. Goodwin voting aye, Ms. Isaac voting no. Have all members voted? Ms. Jones voting aye. Have all members voted? Have all members? Guerin voting no. Have all members voted? 57 ayes, 85 nays. Amendment fails to adopt. Following amendment, clerk will read the amendment.
Amendment by Gonzalez of Dallas.
Ms. Gonzalez.
Thank you, Mr. Speaker. Members, all this amendment does is establish a legislative study committee on fire risk interventions. So basically when this bill passes, the House will select a committee to perform a study that it's evidence-based studies on policies including ERPOs that prevent gun violence while protecting due process and the Second Amendment rights. I think this is a reasonable amendment. When we pass policies or laws here all the time in the abstract, I think it's important for us to actually know the effect that these laws that we pass have on Texans, and I move adoption.
Mr. Hefner in opposition.
Thank you, Mr. Speaker. Members, I oppose this amendment.
Ms. Gonzalez, to close.
Thank you. Again, look, this is a study. It does not change anything else in the bill, and I hope that you will adopt it. Thank you.
Record vote on the Gonzalez amendment. Clerk, ring the bell. Show Ms. Gonzalez voting aye, Mr. Hefner voting no. Ms. Isaac voting no. Have all members voted? Have all members voted? 57 ayes, 85 nays. The amendment fails to adopt. Anyone speaking on, for, or against the bill? Mr. Bernal in opposition.
Thank you, Mr. Speaker. I'll be brief. The last time I was up here was to talk about whether or not we will be consistent in the things that we do and say. And I wanted to point out that here, the argument we're making against red flag laws is that we're concerned that it would violate someone's due process rights, that the threat of violence that they could do to themselves or someone else is not enough. And we use due process as the reason why it's not enough. And about 2 hours ago, we were willing to keep someone behind bars indefinitely because of an accusation and had no regard for their due process rights at all. So I don't think we should stand here and pretend like we're constitutional scholars. We're not. Some of you have done a little bit of reading about the Second Amendment, and that's it. And I would ask you to make it make sense, but you can't because it doesn't. Thank you.
Chair recognizes Ms. Rodriguez Ramos to speak against the bill.
Thank you, Mr. Thank you, Mr. Chair and members. I rise in strong opposition to SB 1362. I believe that the vast majority of gun owners in Texas are committed to being safe and responsible owners of firearms, and they deserve practical common sense tools with which to keep themselves, their families, and their communities safe. I, too, am a gun owner, just like many of our colleagues here, but this bill puts lives at risk by stripping communities of one of those common sense tools available to stop violence before it happens. And not only does it eliminate an option for a policy that we don't even have in place in Texas, it criminalizes the people who try to use this approach. Extreme risk protective orders, or red flag laws, are a civil time-limited way to temporarily separate someone in crisis from their firearms. They are not handed out lightly. They require evidence, they involve a judge, and they save lives. These orders are most often used to intervene in escalating domestic violence situations, to prevent firearm suicides, or to disarm someone making credible threats. And these orders exist because a leading cause of death among pregnant women is being murdered by their intimate partner, most often shot with the firearm. When someone prone to mental health struggles experiences a devastating life event, when a family is desperate for intervention, or when a trusted friend sees a warning sign, ERPOs offer a path to act before the worst case scenario occurs. We should be expanding access to this tool. Texans understand this. A recent poll from the University of Houston found that 88% of Texans support ERPOs, including 86% of independents and 81% of Republicans. This isn't some bleeding heart liberal policy. It's supported by gun owners, law enforcement officials, and mental health advocates alike. In fact, in Texas, in 2024, Texas led the nation with 18 law enforcement officers killed in the line of duty out of a national total of 147, marking a 25% increase from previous years. What does this have to do with the ERPOs? Because the dangers officers face responding to domestic disturbance calls has been identified as particularly hazardous. The more guns available to people in dangerous situations, the more at risk our officers are when they're responding to these calls. A study highlighted that domestic violence incidents are the most dangerous situations for law enforcement, with the DOJ report showing that 40% of our officers' deaths are related to domestic violence calls. The U.S. Department of Justice studies officers' deaths and which calls are the deadliest. The most recent reports illustrate 40% of fatal calls from 2010 to 2016 were related to domestic violence. That number was so high, researchers went into more detail about those cases. In all but one of those cases, the officer was killed with a gun. In 35% of domestic abuse cases, there was only one officer on the scene when the shooting happened. Friends, SB 1362 sends a chilling message. It tells sheriffs, if you intervene to prevent a suicide, you could be prosecuted. It tells judges, your authority stops where political ideology starts. And it tells families, especially those in crisis, that even if you see the warning signs, the state would rather you stay silent. It also rejects cooperation with other states and forfeits federal funds that could support violence prevention, mental health resources, and training for local officers. It's bad policy and it's dangerous, willful negligence. This bill is political posturing dressing up as a constitutional defense with a very real cost measured in human lives. SB 1362 strips away a tool backed by data, supported by law enforcement, and overwhelmingly approved by the public. And it does all this in service of political ideology, not a solution, and not with the vision to help Texas families. I urge you to vote no on SB 1362. Don't criminalize prevention. Don't abandon public safety. Don't continue to put our Texas families, children, teachers at risk. And don't ignore the voices of the people we were here to represent. Thank you so much, and I urge you to vote no on this bill.
Mr. Hefner.
Thank you, Mr. Speaker. Members, I want to close briefly. We just want to make sure that we're protecting people's due process. We're not messing with any of the protective order processes in the family code or the rest of the law. And I want to thank Senator Hughes for working on this. Senator,
Mr. Speaker?
Ms. Weiner, for what purpose?
Will the gentleman yield for a couple questions?
Gentleman yield for questions?
Sure.
Yields for questions.
Representative Hefner, I just want to make sure I understand your bill. Does it prevent the enforcement of extreme risk protective orders?
It prevents local, city, and county governments and subdivision from enforcing extreme risk protective orders. Protective orders that are already in the code, the family code, and the health and safety code still remain, and all those processes are there untouched.
Yes, I understand. I appreciate that you were careful to not touch existing law. It does leave me with the question of where the hypothetical protective orders that this bill would stop enforcement of would come from. Are they currently authorized under state law?
No.
Do localities
But
currently...
they're not really defined in state law, so we define what they are based on what we've seen around the state. And then we are banning or preventing local governments from enforcing these red flag laws.
Okay. So, but these are not currently authorized under current law. Were you concerned that a judge was just going to invent them whole cloth?
I would be concerned with, yes, a rogue city judge, county judge, district judge, whoever in some city or county.
Is that an authority cities and counties currently have under state law?
We have plenty of cities and counties that do things that are that they skate or create things or manipulate things to try to go around state law, and this is to make it explicitly clear that we're not going to violate people's right to bear arms, and we're not going to violate their rights to due process.
So I think as I understand it, right now, it would take a law by the state of Texas, us passing a law for there to be extreme risk protective orders.
Well, I mean,
and after this bill is passed, it would take a law from the state of Texas for us to have extreme risk protective orders.
Well,
Is that
a rational
correct?
person would see it that way, but I do believe we've seen many cities and judges and prosecutors skate the law, manipulate it, or work around it, come up with new things that we have to come down here and chase after them to try to rein them back in. And so this is to define these orders and then to make sure that they do not happen unless we change the law here.
Are you aware of any judge in Texas trying to enforce one of these orders that we don't currently have authorized under state law?
I'm not advised currently, but it's quite common for us to do things here preemptively to prevent local governments or the state from doing things that we might not want them to do.
Are there any types of actions, other types of orders that our district judges or our municipal judges or our county court at law judges can do without state authorization, or do they follow the laws we pass?
They're supposed to follow the law we have. I don't know that they always do that, but that's what they're supposed to do.
Okay. All right. Well, thank you.
Thank you. Again, I'd like to thank Senator Hughes, working with him on this bill, Representative Briscoe Kane has worked on this many sessions. Wes Ferdell helped me a lot on some amendments today. And with that, I move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Mr. Hefner voting aye. Mr. Leach voting aye. Ms. Isaac voting aye. Have all members voted? Have all members voted? 86 ayes, 60 nays. Senate Bill 1362 passed third reading. Chair lays out on second reading. Senate Bill 926. Clerk, read the bill.
SB number 926 by Hancock, relating to certain practices of health benefit plan issuers to encourage the use of certain physicians and healthcare providers and ranked physicians.
Mr. Frank.
Thank you very much. Mr. Speaker, members, this bill allows, it does not require, health insurance plans to provide incentives to customers for shopping for high quality, lower cost medical services. If they do, the bill requires health insurance plans to do so with fiduciary duties. The bill passed House Insurance 8-0. I move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 132 ayes, 0 nays. Senate Bill 926 passed third reading. Chair lays out on second reading. Senate Bill 1494. Clerk, read the bill.
SB number 1494 by Johnson, relating to the authority of certain political subdivisions to change the date of their general elections.
Mr. Anchio.
Thank you, Mr. Speaker and members. This allows local governments to move their elections from May to November of odd-numbered years. Came out of the Senate unanimously. Came out of committee unanimously. We've passed this same bill out of this House already once unanimously. All gas, no brakes. Let's go.
Question occurs on passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 133 ayes, 8 nays. Senate Bill 1494 passed third reading. Chair lays out on second reading. Senate Bill 251. Clerk, read the bill.
SB number 251 by Flores, relating to the creation of criminal law magistrates for Bell County.
Mr. Buckley.
Thank you, Mr. Speaker. This is a local bill that creates criminal law magistrates to expedite proceedings for individuals detained in county jail, and I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Ms. Kerwin voting aye. 135 ayes, 3 nays. Senate Bill 251 passed third reading. Chair lays out on second reading. Senate Bill 456. Clerk, read the bill.
SB number 456 by Middleton, relating to the purchase or sale of human organs, increasing a criminal penalty.
Ms. Lopez.
Thank you, Mr. Speaker. SB 456 addresses illegal organ trafficking by elevating the offense from a Class A misdemeanor to a state jail felony. Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 139 ayes, 0 nays. Senate Bill 456 passed third reading. Chair lays out on second reading. Senate Bill 500. Clerk, read the bill.
SB number 500 by Sparks, relating to the access to certain information in the adoption process.
Mr. Sheen.
Thank you, Mr. Speaker. Members, SB 560 reduces delays in adoption process by requiring the timely release of health, social, and educational reports to licensed child care agencies no later than 45 days after parental rights terminated. Move passage.
Question occurs. Passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 137 ayes, 1 nay. Senate Bill 500 passes third reading. Chair lays out on second reading. Senate Bill 1307. Clerk, read the bill.
SB number 1307 by Cook, relating to the biennial health coverage reference guide developed by the Texas Department of Insurance.
Ms. Simmons.
Thank you, Mr. Speaker. Members, as you can see, I am not Representative Vo, but I am here helping him out today. So this is a bipartisan bill unanimously passed out of both the Insurance Committee and the Senate. SB 1307 asks TDI to consolidate health insurance information into a reference guide for the public, just like Medicaid and CHIP already does. I move passage.
Question occurs on passed third reading. Record vote. Clerk, ring the bell. Ms. Simmons voting aye. Dr. Alverson voting aye. Have all members voted? Have all members voted? Have all members voted? 80 ayes, 62 nays. 1307 passed third reading. Please excuse Mr. Anchia because of an illness on motion. Ms. Rosenthal, is your objection? Chair
Mr.
is not
Speaker?
ordered. Ms. Jones, for what purpose?
Parliamentary
State your inquiry.
Could we slow down just a little bit? The aggression is high, and I just want us to slow down just a little bit. Thank you. Thank you very much.
Chair lays out on second reading Senate Bill 2615. Clerk, read the bill.
SB number 2615 by Creighton, relating to restricting remote work by employees of public institutions of higher education.
Mr. Tepper.
Thank you, Mr. Speaker. This bill establishes consistent telework policies across public institutions of higher education. I have an amendment.
The following amendment, clerk will read the amendment.
Amendment by Tepper.
Mr. Tepper on the amendment.
The amendment ensures employees are allowed to telework in cases of emergencies.
Question
Move
occurs
adoption.
on the Tepper amendment. Record vote. Clerk, ring the bell. Have all members voted? 100 voting aye. Have all members voted? 111 ayes, 33 nays. The amendment is adopted. Following amendment, clerk will read the amendment.
Amendment by Van Dever.
Mr. Van Dever.
Thank you, Mr. Speaker. Members, this is just some wording that will ensure that our dual credit courses are able to be taught remotely. And I believe it's acceptable to the author, and I move passage.
Mr.
Adoption.
Van Dever sends up an amendment. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 127 ayes, 15 nays, 2615 passes to third reading. Mr. Tepper.
Move passage.
Question occurs on passage to third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 92 ayes, 53 nays. Senate Bill 2615 passes to third reading. Chair lays out on second reading Senate Bill 2995. Clerk, read the bill.
SB number 2995 by West, relating to the displacement of student financial aid at public institutions of higher education.
Chair recognizes Ms. Davis.
Thank you, Mr. Speaker and members. This bill provides prospective college students and their families with information about financial aid displacement, how to avoid it, and key deadlines for receiving financial aid. This will be provided through an advisory developed by the Texas Higher Education Coordinating Board and will empower students and families to properly financially plan with complete information. It passed the Senate with unanimous support, both the committee and the House, and the floor. And members, I'm very proud to say that House Higher Education passed this unanimously as well. And with that, Mr. Speaker, I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Ms. Garcia voting aye. Have all members voted? 89 ayes, 56 nays, 2995 passes third reading. Chair lays out on second reading Senate Bill 2321. Clerk, read the bill.
SB number 2321 by King, relating to the regulation of emissions by the Texas Commission on Environmental Quality during an event affecting electric demand or grid reliability.
Mr. Bell of Kaufman.
Thank you, Mr. Speaker. Members, Senate Bill 2321 codifies an existing emergency protocol under which ERCOT may request TCEQ to waive emissions enforcement for backup generation during a crisis. Bill provides regulatory certainty and accountability by requiring operators to minimize excess emissions and maintain proper emergency operation records, TCEQ. Thank you, Mr. Speaker, and I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 139 ayes, 2 nays. Senate Bill 2321 passes third reading. Chair lays out on second reading Senate Bill 2972. Clerk, read the bill.
SB number 2972 by Creighton, relating to expressive activities at public institutions of higher education.
Mr. Leach.
Thank you, Mr. Speaker. Members, I'm taking what could have been a 3 or 4 hour debate, and it's going to be less than 5 minutes, okay? But I've got to lay this out. Senate Bill 2972 is the Campus Protection Act. We've been working collaboratively with many of you here in the body, with our Senate counterparts, with the leadership at our university systems across the state to guarantee the rights of students and faculty to gather peaceably on our college campuses. I do have a floor amendment, and then there's one following this.
Following amendment. Clerk, read the amendment.
Amendment by Leach.
Mr. Leach.
Mr. Speaker, this amendment deals with the use of sound amplification devices. This just simply clarifies when they can be used. In this situation, they cannot be used when there's an intent to intimidate others, to interfere with campus operations, or to interfere with an institution employees or a peace officer's lawful performance of a duty. I move adoption of the Leach amendment.
Mr. Leach sends up an amendment. Record vote. Clerk, ring the bell. Mr. Leach voting aye. Ms. Weiner voting aye. Have all members voted? Have all members voted? 135 ayes, 2 nays. The amendment is adopted. Following amendment, the clerk will read the amendment.
Amendment by
Mr. Turner.
Thank you, Mr. Speaker. Members, I want to thank Chairman Leach for working with me on this amendment. You know, free speech in higher ed has been a hot topic in the legislature for several years now. In 2019, when I had the privilege of chairing the Higher Education Committee, we passed an important free speech bill by Senator Huffman. So I've got some background in this. And I think this bill does a lot of good things that Chairman Leach has brought to the floor today. But I think there's some things we can improve in it, and that's what this amendment does, and I appreciate Chairman Leach working with me on it. Specifically, we're going to preserve some of the protections that Senator Huffman put into law 6 years ago. We're going to make sure that our campuses must provide a public forum for free speech expressions. We're going to strengthen the identification section where someone, any university official can request ID from a student. And lastly, we're going to put in here that anything in this law obviously does not conflict with the U.S. Constitution or the Texas Constitution free speech provisions. It is acceptable to the author. I move adoption.
Turner sends up an amendment. Record vote. Clerk, ring the bell. Show Mr. Leach voting aye, Mr. Turner voting aye, Mr. Moody voting aye, Mr. Wilson voting aye, Mr. Romero voting aye. If all members voted, 120 ayes, 21 nays, amendments adopted. Mr. Leach on the amended bill.
Thank you, Mr. Speaker. I move move passage of Senate Bill 2972, the Campus Protection Act.
Mr. Turner in support of the bill.
Thank you, Mr. Speaker. Members, very briefly, I think this is a good bill. I think it's a better bill now. I'm voting for it. I encourage everyone to vote yes on this bill.
Mr. Leach.
I move passage.
Question occurs on passed third reading. Record vote. Clerk, ring the bell. Ms. Howard voting aye, Mr. Leach voting aye, Mr. Moody voting aye, Mr. Turner voting aye. Have all members voted? Have all members voted? 111 ayes, 27 nays, 2972, passed third reading. Chair lays out on second reading, Senate Bill 973. Clerk, read the bill.
SB number 973 by Eckhart relating to the prohibition on posting on the internet information held by an appraisal district regarding certain residential property.
Chair recognizes Mr. Turner. Mr. Turner.
Thank you, Mr. Speaker. Members, this is a bill that allows appraisal district to post exterior sketches and street-level photos of properties online to improve efficiency and transparency for property owners. I move passage.
Question occurs on passed third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 82 ayes, 57 nays, 97-3, passed the third reading. Chair lays out on second reading, Senate Bill 974. Clerk, read the bill.
SB number 974 by Eckhart relating to the eligibility of a person employed by a school district as a teacher to serve on the appraisal review board of an appraisal district.
Mr. Turner.
Thank you, Mr. Speaker. Members, this is a bipartisan bill allowing teachers to serve on appraisal review boards, addressing county's challenges in finding qualified members.
Mr. Speaker,
Scriven Hawkins, for what purpose?
will the gentleman yield?
Gentlemen, yield for questions.
May I finish my layout first?
Not at this time.
For sure.
The bill also prohibits a school district to communicate with teachers in their capacity as ARB board members with the intent to influence an ARB decision. I want to thank Vice Chair Noble for that excellent idea to add that language into the bill. And lastly, most ARB hearings happen during the summer when teachers are not teaching. So it helps teachers, and it also helps our ARBs be able to find qualified people to serve in these roles. I'd be happy to yield for questions.
Ms. Scriven Hawkins, for what purpose?
Mr. Speaker, will the gentleman yield?
Gentlemen, yield for questions.
Yes.
He yields for questions.
And we're going to slow this train down a little bit so that we can hear and get through some time. What I read on the end of that was a criminal offense. Help me understand that.
So the language we added in the bill in the House committee simply says that if a school district were to try to communicate with, basically have an ex parte communication with an employee of the school district serving in their capacity as an ARB board member, that's a crime because we would not want a school district to try to influence an employee who's serving in the ARB role, because those two roles are totally and completely separate, and they should remain separate, and that's why that provision's in the bill.
I know, but who's the criminal offense, and how does that work? So the teacher is being charged, the school board being charged, and is it a civil? Is it a felony? Since we're putting everybody in jail, what is the criminal offense?
So the bill reads that it's a member of the Board of Trustees of an ISD or an employee of the district commits an offense. So the offense, the barred communication is from the school district, an employee or a board member communicating with the teacher. They would be committing the offense.
And what would it be? What type of offense would it be?
Give me just a second.
I hope we don't want to pay teachers, and then put them in jail.
It took me. No, ma'am. That's not what that's not what this does.
Help us understand.
It's a class A. It's a class A misdemeanor, and it would apply to the school district if a school district employee or board member inappropriately communicated with an ARB board member who is also a teacher in that district. That's all it does.
And so they would go to jail?
It would be a Class A misdemeanor.
And since I'm not a lawyer, what happens with a Class A misdemeanor?
I believe the maximum penalty for a Class A is up to 1 year in jail.
Is what?
Up to 1 year.
Thank you, Representative.
You're welcome. So again, that's just belts and suspenders to make sure that it's clear that there should be no ex parte communication between a school district and a teacher. And I move adoption.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Mr. Turner voting aye. Mr. Patterson voting no. Ms. Morales voting aye. Have all members voted? Have all members voted? Have all members voted? 67 ayes, 79 nays. Fails to pass to third reading. Chair lays out on second reading Senate Bill 865. Clerk, read the bill.
SB number 865 by Alvarado, relating to instruction in cardiopulmonary resuscitation and the use of automated external defibrillators for school district, private school, and open enrollment charter school employees and volunteers.
Mr. Leach.
Thank you, Mr. Speaker. Members, in November of 2023, we were in this room during a special session late at night like we are now. I walked downstairs to my office on the ground level, and when I walked down the stairs, just right down here on the west side, our good friend, many of you know him, John Pitts, a lobbyist here in Austin, and brother of our former colleague Jim Pitts, who's now since gone to be with the Lord, right in front of me had a heart attack, had a heart condition, and fell before me. DPS troopers were there, and he was gone. He was gone. I immediately texted Dr. Bonin, Dr. Oliverson, and Dr. Howard, who ran down from this floor and utilized what's hanging on the wall downstairs, and that's an AED device, an automated external defibrillator. Had it not been for the presence of that AED device, but not only the presence of that AED device, but the training and the experience and the capability of Drs. Bonin, Dr. Oliverson, and Representative Howard, who knew how to utilize those AED devices, Mr. Pitts, who we all know and love, would not be with us today. Members, what this bill does is it simply seeks to address the deficiencies by mandating CPR training for certain school staff, reinforcing the importance of preparation and fostering a culture of safety within our Texas schools. If we have people here at the Texas Capitol who know how to use those AED devices, that should also be required in our Texas public schools, and that's what this bill seeks to address. And with that, Mr. Speaker, I proudly move passage.
Mr. Speaker.
Ms. Rosenthal, for what purpose?
Does the gentleman yield for
Gentleman
a
yield for
very quick
questions?
question?
Yes, very quickly. Very quickly.
Do I not have the right?
You do,
to ask a
Representative
question?
Rosenthal, I'm listening.
So I just want to make it clear that since my freshman session, I've advocated for this. We had 2 different boys in high school die of sudden cardiac arrest in my district in the time that I've been here. So I just want to thank you very much for bringing this bill. I hope it's a unanimous vote.
Thank you, Representative Rosenthal. I'm very proud to bring this bill. Many of us have cared about this, and I bring this to you on behalf of all of them. With that, I move passage.
Ms. Morales in favor.
Thank you, Mr. Speaker and members. If you'll just take a minute to listen to this story about somebody who wasn't quite so lucky. And I just so much appreciate this bill, and I thank Representative Leach for bringing it forward. Landon Payton was just 14 years old, a student at Marshall Middle School in my district in Houston. And on August 14, 2024, during a gym class, Landon collapsed unexpectedly. Despite immediate efforts by the school, staff, and emergency responders, he was pronounced dead shortly thereafter. To this day, his family is still waiting for answers. The cause of his death remains officially undetermined, and the questions are painful. Was the equipment working? Was the staff properly trained? Could more have been done? I met with Landon's father, Alexis Payton, the day after his son's tragic passing. The pain in his eyes was indescribable. That very morning, I sent a letter to Houston ISD and the Texas Education Agency demanding answers. To date, we really have not received a clear response. The silence is deafening, and the lack of transparency is unacceptable. We know that these AEDs, these defibrillators in the school gym, had expired pads at the time of the incident. So this bill is so important because it seeks to address these very issues by mandating comprehensive CPR and AED training, and by for school personnel, including nurses. So I love that that's in this bill. It also requires schools to develop a cardiac emergency response plan, ensuring that staff are prepared to act swiftly and effectively in the face of medical emergencies. Folks, while we cannot bring Landon back, we can honor his memory by taking these concrete steps to protect other students. It's a small but significant way to show that we care and that we're listening and that we're taking action. Thank you.
Leach to close.
Move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Mr. Leach voting aye. Morales Shaw voting aye. Ms. Morales voting aye. Have all members voted? Have all members voted? 120 ayes, 15 nays. Senate Bill 865 passes third reading. Chair lays out on second reading. Senate Bill 506. Clerk read the bill.
SB number 506 by Betancourt relating to requirements for certain petitions requesting an election, ballot propositions, and to related procedures and provisions.
Mr. Paul.
Mr. Speaker, members, this bill is a good bill to take care of those problems that we have at home where local communities have ambiguous language on ballots. This bill makes sure that you can send those to the Secretary of State and have a way of process to make sure those ballot languages have meaning. And I have a perfecting amendment.
Following amendment, clerk read the amendment.
Amendment by Paul.
Mr. Paul.
This amendment just fixes the timeline inside the bill. Move adoption.
Question occurs on the Paul amendment. Record vote. Clerk ring the bell. Mr. Busey voting aye. Have all members voted? Have all members voted? 133 ayes, 7 nays. Amendments adopted. Following amendment. Clerk read the amendment.
Amendment by Busey.
Mr. Busey.
Hey, Mr. Speaker and members, this amendment would authorize the city to send its ballot language to the Secretary of State for pre-clearance, and it is acceptable to the author. I move adoption.
Busey sends up an amendment. Questions on the Busey amendment? Record vote. Clerk ring the bell. Mr. Busey voting aye. Mr. Tepper voting aye. Mr. Alverson voting aye. Mr. Paul voting aye. If all members voted, 136 ayes, 0 nays. Amendment is adopted. Following amendment. Clerk will read the amendment.
Amendment by Tepper.
Mr. Tepper.
Thank you, Mr. Speaker. This amendment ensures that the ballot proposition complies with state law.
Mr. Speaker.
Move adoption.
Ms. Wiener, for what purpose?
Will the gentleman yield for some
Gentleman
questions?
yield for questions?
Yes.
He yields for questions.
Thank you, Representative Tepper. Can you explain to me how this changes the impact of the bill?
It would allow the Attorney General to review the ballot proposition to ensure that it complies with state law.
I'm sorry, is the Attorney General currently on this bill?
I don't believe so, but it would be a process where the language would comply with state law.
Hey, Mr. Speaker,
Ms. Wiener, for what purpose?
I raise a point of order under Rule 11, Section 2, that this amendment violates, or this amendment is not germane to the bill.
Bring your pointer right in front. The point of order has been withdrawn. The amendment's been withdrawn. Mr. Paul on the bill as amended.
Move passage.
The question occurs on passage third reading. Record vote. Clerk, ring the bell. Busey voting aye. Paul voting aye. Have all members voted? Have all members voted? 111 ayes, 21 nays. Senate Bill 506 passes third reading. Okay. Let's go one with the other. Chair lays out on second reading, Senate Bill 781. Clerk, read the bill.
SB number 781 by King relating to certain files maintained by the law enforcement agency regarding certain employees of the agency.
Mr. Hefner for a motion.
Mr. Speaker, I move to postpone further consideration of SB 781 until 10:15 today.
Members, you've heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading, Senate Bill 1522. Clerk, read the bill.
SB number 1522 by Perry relating to the regulation of continuing care facilities.
Ms. Rose.
Thank you, Mr. Speaker. Members, continuing care retirement communities, or CCRCs, offer older Texans a promise of aging in a place through progressive levels of care, including independent living, assisted living, and skilled nursing. HHSC licensed these communities to provide care, but the Department of Insurance regulate these CCRCs because they function as an insurance-type product. So current statute governs these CCRCs are outdated. So Senate Bill 1522 will revise terminology, strengthen consumer protections, and clarify TDI's oversight. So move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 141 ayes, 0 nays. Senate Bill 1522 passes third reading. Chair lays out on second reading, Senate Bill 1558. Clerk, read the bill.
SB number 1558 by Perry relating to the liability of nonprofit entities contract with the Department of Family and Protective Services or with a single source continuum contractor to provide community-based care or child welfare services.
Dr. Bonham.
Thank you, Mr. Speaker. Foster care providers are required by contract and by state law to carry liability insurance coverage. However, these providers are experiencing skyrocketing insurance premiums. Limited carrier.
Does the gentleman yield for questions?
No, I don't. I'm going to finish my layout. Limited carrier availability and burdensome policy changes. This legislation clarifies existing law to provide separation between good providers who want to serve children in our foster care system and the perpetrators who harm children or contribute to the harm without any previous indication that they would do so. Without clarification in Texas law, Texas, like other states around the country, risks leaving thousands of children without placement and destabilizing our foster care system. This legislation reinforces the existing protections of the Charitable Immunity and Liability Act to make it clear that a nonprofit foster care provider and the nonprofit single source continuum contractors who provide community-based care are protected by the Charitable Immunity and Liability Act. This clarification will give clear direction for insurers so that providers can access more options for the required liability insurance coverage. Further, this establishes what foster care providers must do to be determined to be in good standing, meaning they have taken appropriate actions to ensure that background and registry checks, training, and necessary reporting or personnel actions have occurred. This will ensure that those who harm or directly contribute to the harm of a child continue to be liable while providing some separation for providers when nothing in due diligence process indicated or suggested that harm would come to a child. This legislation clarifies immunity for groups currently included under the Charitable Immunity and Liability Act, and it does not extend any protections to for-profit entities. This legislation does not provide additional protection for those who harm or directly contribute to harming children in foster care, and this legislation does not change who can sue for damages and does not modify the statute of limitations on any suits. There's a very serious concern that without legislative action, foster care providers will not be able to provide appropriate liability insurance coverage, which they are required to have by law, and children will be without necessary foster care placement.
Mr. Speaker,
Ms. Gonzalez, for what purpose?
does the gentleman now yield?
Gentleman yield for questions?
Yes.
He yields for questions.
Thank you, Dr. Bonin. And I know this bill came through JCJ, which I serve on, and so just have a few questions. So in your bill, it provides for certain immunities to nonprofit entities and their staffers under specified conditions, correct?
Yes.
Could you clarify the rationale behind offering such broad immunity, especially in relation to statutory requirements for maintaining in good standing?
Yeah, so let's be clear, the immunity is actually not broad. We're talking about vicarious liability, and they're only protected from that if they meet very specific requirements. Specifically, they must have conducted timely criminal background checks for the employee as required by law before hiring, contracting with, or otherwise enlisting the services of the person, and then at least once every 5 years they have to have confirmed the person is not listed in a state registry or database that indicates the person is ineligible to supervise or treat children. They must have reported any known allegation of misconduct by the person as required by law. They must have taken timely and proportionate administrative or personnel action in response to deficiency in the performance of duties by the individual, and required the person to complete training for A, child sexual abuse prevention at least once every 5 years, and B, the reporting of child abuse and neglect. Additionally, with respect to any given incident, the entity was, in order to not have this protection, they have to have not been in substantial compliance with the requirements that were described, and the requirement had to have been designed to prevent the specific type of harm that was alleged to have occurred.
So you kind of answered my next question. You mentioned substantial compliance. Was that the list, the items that you just mentioned?
Yeah,
that they had to, okay.
That is the list, and then I was going through another section, and there's some other elements that they also have to meet.
Okay, so it has these specific guidelines that they have to meet laid out in your bill.
Correct.
Correct. Okay.
They have to be compliant with these.
Okay.
Substantially compliant.
Okay. And so, what's substantial? I mean, who determines if it's substantial or not?
Yeah, this would be important in a court of law if there was a case, and the difference here obviously being substantial compliance, meaning that they have complied with the law, whereas if it's not substantial compliance, then even a technical deficiency could potentially open them up to liability.
Okay, so this bill, it limits liability except in cases of gross negligence, correct?
Correct, that's right.
So does granting immunity to nonprofits except in cases of gross negligence, do you think that risks prioritizing organizational protection over the safety and rights of service recipients?
I think we've gone to great lengths to make sure that these providers are fully following the guidelines that have been set out to protect kids.
Thank you, Dr. Brown.
Following amendment, clerk will read the amendment.
Amendment by Dutton.
Mr. Dutton.
Thank you, Mr. Speaker. I think this makes this bill a little better because I think the questions that were just asked had to do with substantial compliance. We require the providers to do certain things to get the immunity on one hand, and on the other hand, we say if they substantially comply, they can get the immunity. That's to me is going to cause more lawsuits about what substantial compliance means. And so what my amendment does is simply take the word substantial out so that either the provider complied with the requirements we gave them or they didn't. And that won't lead to many arguments. And so I move adoption of the amendment.
Mr. Speaker.
Ms. Gonzalez, for what purpose?
Does gentleman yield for a quick
Gentleman
question?
questions? He
Yes.
yields for questions.
So
Yes.
I just looked at your amendment. So So your bill took, or your amendment took out substantial, so now they would, a person, or I guess an entity or what have you, would have to comply with all the
Correct.
factors that are laid out.
Correct.
Okay, thank you.
So that we don't have an argument about what substantial is. It's kind of like, you know, the Ten Commandments. Either you complied with them or you didn't.
Yes.
And I don't think the good Lord would let us substantially comply.
I agree. Good amendment. I'll be supporting it.
All right, thank you.
Dr. Bonin in opposition.
Yeah, members, this is actually really important. The providers would still have to be substantially compliant with all of the elements. What this is saying is that even if they had materially and substantively done everything they were supposed to do on a technical error or omission, such as not having an appropriate date, they could be then exposed to vicarious liability. That is a big change, and so I'm opposing this amendment, and I move to table.
Mr. Dutton to close.
Members, nowhere else on the law do we grant immunity and then say that all you have to do is substantially comply to get that immunity. Nowhere else in the law does that happen. You either comply with the terms or you don't comply with the terms. And what this is going to do is lead to more lawsuits, because the lawsuits are going to be about whether you substantially complied or not. That's not a defined term, and so it is going to be difficult to determine whether or not there's substantial compliance or not. That's going to be a fact issue, and the fact issues are going to go to the jury, for the jury to decide. And I don't think this bill ought to create more lawsuits. I agree with what he's doing. I just want to take the uncertainty out of it, and the uncertainty that exists now is whether or not a provider substantially complied. That's all there is to it. I don't think we ought to leave anything uncertain about whether or not they've complied. And to leave the term substantial in there means that we're going to be saying, well, we're not sure whether you complied or not. And so what my amendment does, it says that here are the terms you have to complete. Here's the things that we said you have to do. And if you do them, you get the immunity. And if you don't do them, you simply don't get the immunity. And I don't know why that would be so difficult, but I think as a lawyer, I really don't want any more lawsuits than we need to, especially around things that we could have settled in this chamber. And so I would ask you to vote no on the motion to table. That's no on the motion to table, to make sure that substantial compliance is out of this bill, and either the providers complied or they did not.
Record vote on the motion to table. Clerk, ring the bell. Show Dr. Bonin voting aye, Mr. Harris voting aye, Mr. Dutton voting nay, Mr. Busey voting nay, Mr. Vasut voting aye, Mr. Leach voting aye. Have all members voted? Have all members voted? 86 ayes, 56 nays. The motion to table fails. Dr. Bonin.
Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Shaheen voting aye, Vasut voting aye, Tinderholt voting aye. 94 ayes, 49 nays. Senate Bill 1558 passed third reading. Mr. Leach for notice.
Thank you, Mr. Speaker. Pursuant to Rule 7, Section 37C, I hereby give notice that I intend in at least 1 hour's time to move to reconsider the vote by which Senate Bill 974 was defeated.
Members, it's just notice.
Chair lays on second reading Senate Bill 510. The clerk will read the bill.
SB number 510 by Betancourt, relating to the failure of voter registrar to comply with voter registration laws.
Chair recognizes Mr. Shaheen.
Mr. Speaker, member SB 510 seeks to ensure that voter registers maintain accurate and up-to-date voter rolls by expanding enforcement mechanisms available to the Secretary of State. Allows the Secretary of State to withhold Chapter 19 funds if voter registration fails to secure a hearing and deliver notice to parties. There is an amendment.
The following amendment, the clerk will read the amendment.
Amendment by Busey.
Chair recognizes Mr. Busey on the amendment.
Thank you, Mr. Speaker. Members, this amendment allows for counties to correct the alleged violation after notification from the Secretary of State before Chapter 19 funds or other federal election administration funds are withheld from the county. I want to thank my chairman and sparring partner for working with me on this, and it is acceptable, and I move adoption.
Mr. Busey sends up an amendment. It is acceptable to the author. Is there objection to the adoption of the amendment? Chair, none amendment is adopted. Chair recognizes Mr. Shaheen to close on the bill.
Move passage.
Members' question occurs on passage to third reading, Senate Bill 510. Record votes been requested. Clerk reading the bill. Show Mr. Busey voting aye. Show Mr. Shaheen voting aye. Have all members voted? Have all members voted? There being 113 ayes, 21 nays, Senate Bill 510 passes to the third reading. Chair lays that on second reading, Senate Bill 667. The clerk read the bill.
SB number 667 by Hughes, relating to the prohibiting state retirement systems from investing in certain Chinese-affiliated entities.
Chair recognizes Mr. Berry.
Thank you, members. Thank you, Mr. Speaker. Members, appreciate your consideration for Senate Bill 667, a crucial measure to divest Texas taxpayer retirement funds from companies compromised by the influence of the Chinese Communist Party. The bill seeks to align our investment strategies with national security interests and fulfill our fiduciary responsibilities by divesting from compromised entities. Senate Bill 667 does this by addressing national security, economic impact, fiduciary responsibility, reporting and accountability, legal and administrative framework. With that, Mr. Speaker, move past.
Mr. Wu, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions.
I'll yield for questions.
Gentleman yields.
Representative Berry,
How are
can I
you?
ask you a few questions about your intent on this bill?
Sure.
On here, on page 1, on line 18, you note that part of the requirement is that a company has to be publicly confirmed to be controlled by the People's Republic of China, et cetera, et cetera. What does publicly confirmed mean?
Well, publicly confirmed can mean that entity has identified themselves as someone who is affiliated with the party and or the Department of Defense
That
through
either
the Comptroller's office.
That either the United States government identifies them correctly.
That is correct.
2, that they identify themselves.
That is correct.
3, that they're identified by the PRC.
That is correct.
All right.
And Mr. Wu, the biggest point I want to make is that to give you just an idea, the systems that we're referring to specifically in this bill are the employees' retirement system, the teacher retirement system, Texas Municipal Retirement System, Texas County and District Retirement System, the Texas Emergency Services Retirement System, and the Permanent School Fund, of which there are no more than 2% of funds invested in those entities.
So, Mr. Berry, why are you adding Hong Kong in?
Well, they're publicly identified as that party. That's their political strategy as a country.
Because all the other bills dealing with critical infrastructure, dealing with land ownership and everything else, Hong Kong is not mentioned in any of those other bills. It's not mentioned in the DNI list. It's not mentioned in any of the other risk assessments. Because right now, Hong Kong, you still have a separate passport. You still have separate governments. Many of the corporations who are there were there long prior to the takeover.
I understand.
Okay. And why just China? Because again, like in many of the other bills, for example, SB 17 for Mr. Hefner, many of the critical infrastructure bills, the list is the DNI list, which includes China, Russia, Iran, and North Korea. Why not the entire list? Why just one country?
Well, to be quite honest, the author is actually decided to choose the methodology in China in this particular case.
So there's not, that's what they felt like.
That's right. It's Senator Hughes' bill.
Okay.
I'm not advised as to why only China.
Thank you very much.
Thank you. Move passage.
Anyone wishing to speak on for or against? Chair recognizes Mr. Wu to speak against.
Mr. Speaker, members, I was worried about what this bill would do. I was worried about the tone it would set, because divesting from other countries doesn't lower temperatures, it raises temperatures. There's a reason why the EU spent so much time putting itself together, because the idea was if everyone's tied together, everyone's investing in each other, then you can't make war with each other. You can't fight each other when your economic hands are tied together. Here, this is not even, I don't think we even need to go there, because this is purely performative. This is a purely performative bill, because if you look at what's in the bill, if you flip to the backside, you look on page 8, page 9, page 10, what you will see is a requirement that our agencies divest from certain holdings in China, and every single one of these has an exception that says, unless we might lose money. Not a lot of money, but any money. And so that is the strength of your resolve to do this. That this is just a farce. This is a show to pretend that you're doing something when you're actually not. But I think this is still bad policy. Because, again, we're asking the comptroller to make determinations of what is in the best interest of national security, and then we're going to make our investment decisions based on that. We're going to ask our state to divest from investments in other places that are earning us money, that are earning us good money. And it just makes no sense. Because if you're going to do this, then you should do it regardless of whether you lose money. If you're so concerned about national security, so concerned about the state, the security of the state, then you should do this whether you lose money or not. But because every single one of these has a provision that says, well, we really would like you to do this, you're commanded to do this unless we lose money on it. That's a joke. It's another attempt, another way to gin up hate, to gin up discontent, to gin up discord, and gin up division. I would ask you to vote no. If this ends up hurting our retirement system, if this ends up losing money for the retirement system, blame it on the people who voted yes.
Chair recognizes Mr. Berry to close.
Mr. Speaker, thank you. I want to just say that the bare essence of an investment is that we take our money from America or Texas, our taxpayers, and send it to an entity so that they can build their infrastructure and make money and give us a return on our investment. Move passage.
Members, the question occurs on passage to third reading of Senate Bill 667. A record vote has been requested. The clerk will ring the bell. Show Mr. Leach voting aye. Have all members voted? Have all members voted? There being 87 ayes, 54 nays, Senate Bill 667 passes to third reading. Chair lays it on second reading. Senate Bill 763. Clerk, read the bill.
SB number 763 by Alvarado, relating to the renewal and review of the standard permits of certain concrete plants.
Chair recognizes Mr. Bello Kaufman.
Thank you, Mr. Speaker. Members, Senate Bill 763 requires TCEQ to conduct a protectiveness review of standard permits for concrete batch plants every 10 years rather than on an as-needed basis or on request. The protectiveness review will not apply to the standard permit with enhanced controls. Thank you, Mr. Speaker, and I move passage.
Members, the question occurs on passage to third reading of Senate Bill 763. This is a record vote. The clerk will ring the bell. Have all members voted? Have all members, show Mr. Alders voting aye. Have all members voted? There being 122 ayes, 18 nays, Senate Bill 763 passes the third reading. Chair lays out Senate Bill 781 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 781 by King, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Chair recognizes Mr. Hefner.
Thank you, Mr. Speaker. Members, this is about personnel files for Texas law enforcement officers which have no standard across the state for the confidentiality of such records, and the release of these records depends on whether the political subdivision has adopted a provision in state law to protect certain information pertaining to a police officer or firefighter. Peace
Speaker.
officers,
Mr.
department
Wu, for
files.
purpose.
I'll wait till after the layout.
Okay. Not at this time. Continue, Mr. Hefner.
Okay. Recently, as part of the TCOL Sunset Bill, committees were formed to contemplate and draft model policies which law enforcement agencies shall adopt. One of those areas was a policy on personnel files, and the final adoption by the Commission occurred in April of 2024. The new policy, drafted as a legislative mandate by a committee of stakeholders, sworn and non-sworn, reflects the language and confidentiality provided in Chapter 143 of the Local Government Code and mandates this practice apply statewide for law enforcement officers. Peace officers' department files should be uniform across the state. Confidentiality should not be dependent upon which law enforcement agency or department you are employed by. I do believe I have some amendments.
Mr. Wu, for what purpose?
Will the gentleman yield for a question?
Gentleman, you for a question.
Yes.
Mr. Hefner, the intent of your bill is to make uniform across the state the retention and the release of these records, correct?
Yes.
Okay. Thank you.
As based on the recommendations and the model policies put forth by the TCOL and the committee that put those policies together.
Thank you. Mr. Speaker.
Mr. Wu, for what purpose?
I raise a point of order against further consideration of STD 781 under Rule 4, Section 32C on the basis of the bill analysis is incorrect.
Please bring your point of order down front.
The point of order has been withdrawn. The chair recognizes Mr. Hefner for a motion.
Mr. Speaker, I move to postpone further consideration of Senate Bill 781 until June the 3rd, 2025.
Members, you've heard the motion. Is there objection? Chair hears none, so ordered. Chair lays out on second reading Senate Bill 2073. The clerk will read the bill.
SB number 2073 by Zapparini relating to the authority of an appraisal district to purchase, finance the purchase of, or lease real property, or finance the construction of improvements to real property.
Chair recognizes Mr. Guillen.
Thank you, Mr. Speaker. Members, this clarifies that appraisal districts may finance property purchases. Move passage.
Question occurs on passage to third reading of Senate Bill 2073. This is a record vote. The clerk will ring the bell. Show Mr. Guillen voting aye. Show Mr. Kane voting no. Show Mr. Basut voting no. Show Mr. Metcalf voting no. Show Mr. Bojani voting aye. Show Mr. Wiener voting aye. Show Mr. Paul voting no. Have all members voted? Have all members voted? There being 75 ayes and 52 nays, SB 1858 is passed at third reading. Mr. Hayes, for what purpose?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, you aware this body has now endured 200 points of order for a total of 67 hours.
Mr. Hayes, that is not a proper parliamentary inquiry.
We're on 1858.
Chair lays out on second reading Senate Bill 1858. The clerk will read the bill.
SB number 1858 by Hagenview relating to eligibility for bulletproof vest and body armor grant program.
Chair recognizes Mr. Leach.
Thank you, Mr. Speaker. Members, this bill ensures that ISDs can receive funding to equip their officers with necessary protective gear, specifically bulletproof vests. Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Mr. Pursuit voting aye. Have all members voted? Have all members voted? 131 ayes, 5 nays. Passes third reading. Chair lays out on second reading Senate Bill 1660. Clerk, read the bill.
SB number 1660 by Huffman relating to the retention and preservation of toxicological evidence of certain intoxication offenses.
Mr. Cook.
Thank you, Mr. Speaker. Senate Bill 1660 aims to clear up ambiguity in current law regarding when toxicological evidence can be disposed of in cases where the retention period has expired. Updating the statute related to this type of evidence reflects the modern needs of today's law enforcement needs. There is an amendment.
Following amendment. Clerk, read the amendment.
Amendment by Jones of Harris.
Ms. Jones.
This amendment ensures due process and confrontation of rights for the accused. The amendment is acceptable by the author. I move adoption.
Ms. Jones has an amendment. It's acceptable to the author. Is there any objection? Chair hears none. The amendment is adopted. Mr. Cook to close.
Move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 113 ayes, 24 nays. Senate Bill 1660 passed third reading. Chair lays out on second reading Senate Bill 505. Clerk, read the bill.
SB number 505 by Betancourt relating to processes to address election irregularities, providing a civil penalty.
Ms. Swanson.
Mr. Speaker.
Salary for what purpose? Ms. Swanson for a motion.
Mr. Speaker, I move to postpone further consideration of SB 505 till 11:30 p.m. today.
Members, you've heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading Senate Bill 2900. Clerk, read the bill.
SB number 2900 by Colkhorst relating to the review of existing boards and commissions under the jurisdiction of the comptroller for continuity and the repeal of certain committees under the jurisdiction of the comptroller.
Mr. Bojani.
Thank you, Mr. Speaker. Members, this is a cleanup bill that will increase efficiency in the Comptroller's office by allowing for review and repeal of boards that are no longer staffed and functioning. I believe Chairman Guerin has an amendment that he's filing right now. I can quickly talk more about this bill. It requires the Comptroller to review each of its advisory entities, including boards, committees, councils, and task forces, to assess whether they are necessary and support the efficient and effective operation of the Comptroller's office. I have an amendment. Oh, Chairman Guerin has an amendment.
The following amendment. The clerk will read the amendment.
Amendment by Guerin.
Mr. Guerin.
Thank you, Mr. Speaker and members. This floor amendment to SB 2900 makes technical corrections requested by the comptroller to streamline the efficiency of comptroller operations, protecting the comptroller's investment advisory board and ensuring compliance with the tobacco settlement. And I move passage.
Mr. Speaker.
Ms. Weiner, for what purpose?
Will the gentleman yield for some questions?
Gentleman yield for questions?
Yes.
He yields for questions.
Thank you, Representative Guerin. I apologize for needing some more information, but we've got a 5-page amendment here. Now, does this tie directly to Representative Bojani's bill, or is this a separate bill that we're putting on
This
here?
is not a separate bill. This is all it is. This is not a bill that was filed by anybody that I'm aware of, and it protecting the comptroller's investment advisory board and ensuring compliance with the tobacco settlement from years ago.
Okay. Why? Could you explain the need for this a little bit more, like the need for compliance while I'm scrolling
It
through?
specifically amends the Tobacco Settlement Permanent Trust Account statutes to clarify responsibilities for the Texas Treasury Safekeeping Trust Company and the Tobacco Settlement Administration Committee. This will ensure that the Trust Company and Administrative Committee continue to conduct all functions necessary to comply with the tobacco settlement, while also allowing for the repeal of the Duplicative Tobacco Settlement Advisory Committee. It revises the Comptroller's Investment Advisory Board to align its responsibilities with the Texas Treasury Safekeeping Trust Company Investment Advisory Board, which the bill repeals. This will ensure the Comptroller's Investment Advisory Board handles its duties to advise on state investments in a transparent and accountable manner. It allows reasonable compensation for board members out of the Texas Treasury Safekeeping Trust Company budget for actual and necessary expenses to attend meetings of the board in line with existing statute. It ensures board members can receive compensation performing their duties, which could be precluded without explicit statutory authorization. It revises the Comptroller's semi-annual historically underutilized business report to be an annual report. It strikes the requirement that agencies report hub data to the Comptroller by March 15th of each year, while maintaining the requirement that they report this information to the Comptroller by September of each year. It strikes the requirement that the Comptroller report the preceding 6 months of hub data to the legislature by May 15th of each year, while maintaining a requirement the Comptroller report all data for the preceding fiscal year by November 15th of each year, which that way as you know, our fiscal year ends on August 31st, and so it's a yearly report, and repeals any additional obsolete and inactive committee at the Comptroller's office, the Community Reinvestment Act Advisory Committee.
Thank you so much, Chairman, for your gracious and clear explanation of a big amendment on a chaotic night.
Thank you, ma'am. I move, it is acceptable to the author, I believe, and I move passage.
Mr. Guerin sends an amendment. It's accepted to the author. Is there objection? There is objection. Record vote. Clerk, ring the bell. Mr. Meyer voting aye. Dr. Alverson voting aye. Mr. Guerin voting aye. Mr. Bojani voting aye. Ms. Bowers voting aye. Have all members voted? Have all members voted? 109 ayes, 33 nays. The amendment is adopted. Mr. Bojani on the bill.
I just want to quickly thank Nick Watt and Ryan Marquez from Ways and Means, and I move adoption. Or my move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Swore Johnson voting aye. 107 ayes, 32 nays. Senate Bill 2900 passes third reading. Chair lays out on second reading Senate Bill 1433. Clerk, read the bill.
SB number 1433 by Betancourt relating to the assertion of legislative privilege by the Attorney General and certain legal challenges to the constitutionality of state statutes.
Mr. Smithy.
Mr. Speaker, members, this bill permits the Office of Attorney General to assert legislative privilege on our behalf in litigation temporarily until we have an opportunity to assert it on behalf of ourselves.
Mr. Speaker.
Mr. Wu, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions?
Yes.
He yields for questions.
Thank you, Representative Smithy. I'm sorry. Thank you, Chair Smithy. When does your bill describe when the Attorney General may assert legislative privilege?
Well, when would be when it comes up in a proceeding. And an example would be if there is a lawsuit against the Office of the Comptroller, and in a deposition, the lawyer for the plaintiff were to ask the employee or agent in the Comptroller's office, did Representative Wu say anything to you? Did you have any conversation with Representative Wu when he passed this bill or before he passed this bill? That is your privilege to assert. It may be covered by legislative privilege, may not be. But the point is that the state, the employee of the Comptroller's office should not have to disclose that until you have had a chance to assert legislative privilege. And so the Attorney General would assert on your behalf and then would have 30 days to notify you to decide whether you wanted to assert it on behalf of yourself.
And thank you very much.
Okay, move passage.
Question occurs on passage. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 91 ayes, 48 nays. Senate Bill 1433 passes third reading. Chair lays out on second reading Senate Bill 1540. Clerk, read the bill.
SB number 1540 by Betancourt relating to maintaining the confidentiality of the personal information of election officials and their employees.
Mr. Capriglione.
Thank you, Mr. Speaker. Members, Senate Bill 1540 enhances the safety and privacy of our election officials and their staff by extending confidentiality protections to election employees. I have an amendment.
Following amendment, clerk will read the amendment.
Amendment by Capriglione.
Mr. Capriglione.
Mr. Speaker, members, this amendment adds state executive committee members, their officers, so they too can be afforded these disclosure protections. I move adoption.
Mr. Speaker,
Ms. Wiener, for what purpose?
will the gentleman yield for a question?
Gentleman yields
Yes.
for questions. He yields for questions.
Yeah, I apologize, Representative Capriglione. Could you tell me this big list we're adding folks to, what the impact of that is in election code?
So what we're doing is we're adding certain protection for the safety and privacy of our election officials and their staff, and that includes protecting information such as their home address, their home telephone number, their emergency contact information, their date of birth, their social security number for that individual and his or her family members, and it protects that information from being disclosed from a variety of different government entities.
Thank you, Chairman.
I move passage.
The question is on the amendment. Is there any objection? Chair hears none. The amendment's adopted. Mr. Capriglione to close.
Thank you. I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. 100 voting aye. Have all members voted? Have all members voted? Being 140 ayes, 0 nays, Senate Bill 1540 passes third reading. Chair lays out on second reading Senate Bill 1964. Clerk, read the bill.
SB number 1964 by Parker relating to the regulation and use of artificial intelligence systems and the management of data by governmental entities.
Mr. Capriglione.
Thank you, Mr. Speaker and members. Senate Bill 1964 modernizes Texas's AI governance by establishing clear definitions, ethical standards, and oversight mechanisms for AI systems used by state and local governments. I have two amendments.
The following amendment, the clerk will read the amendment.
Amendment by Capriglione.
Mr. Capriglione.
Mr. Speaker, members, this amendment makes changes to the definition of consequential decision, combining the terms material legal or similarly significant to clarify that material evidence is significant and relevant in a legal setting. I move adoption.
Mr. Capriglione sends up amendment. It's acceptable to the author. Is there any objection? Chair has none. The amendment is adopted. Following amendment, the clerk will read the amendment.
You would witness murder on live TV.
Amendment by Capriglione.
Mr. Capriglione.
Thank you, Mr. Speaker. Members, this amendment allows for hospitals to satisfy the disclosure requirements under Section 2054.711. I move adoption.
Mr. Capriglione sends up an amendment. It's accepted to the author. Is there objection? Chair has none. The amendment is adopted. Mr. Capriglione to close.
I move passage.
Question occurs on final passage. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? 119 ayes, 23 nays. Senate Bill 1964 passes third reading. Chair lays out on second reading Senate Bill 1300. Clerk read the bill.
SB number 1300 by Flores relating to the prosecution and punishment of the criminal offense of organized retail theft, increasing criminal penalties.
Chair recognizes Mr. Cook.
Thank you, Mr. Speaker. Senate Bill 1300 establishes a new offense for organized retail theft. Based on the crimes that have occurred in many different department stores and places like Home Depot, this new crime for organized retail theft is necessary, and I move passage.
Question occurs on passage third reading. It's a record vote. Clerk ring the bell. Have all members voted? Have all members voted? 116 ayes, 25 nays. Senate Bill 1300 passes third reading. Chair lays out on second reading Senate Bill 1644. Clerk read the bill.
SB number 1644 by Schwartner relating to the use of consumers' credit score in the underwriting or rating of certain personal lines, property, and the casualty insurance policies.
Mr. Smithy.
Thank you, Mr. Speaker. This is a recommendation by the Office of Public Insurance Counsel, and it provides fairness in the way insurance companies use credit reports to set insurance rates.
Mr. Speaker?
Ms. Collier, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for
Yes, I
questions.
yield.
He yields for questions.
Thank you so much, Chair Smithy. I want to just make sure I have a clear understanding of what the bill does. Does this apply to homeowners insurance?
Yes, it applies to any personal lines, which would, for most people, would be homeowners and auto.
And what was the last one?
Automobile insurance.
Oh, so that was my next question. Does
Yeah.
this apply to car insurance?
Yes, personal lines, and for most people, that's going to be homeowners and automobile.
And right now, do underwriters, are they required to reevaluate one's insurability every so often, or?
No, this bill would require they do it every 3 years. And if they're going to do anything that's adverse to you as a policyholder, they have to use a credit score that is not more than 90 days old.
Not more than 90 days old?
Yes.
So right now, can a consumer request that their, I guess, their insurability be reevaluated?
Some companies will permit you to do that. You know, some companies don't use credit scores at all in their underwriting, but other companies do. They use it differently. They have different models they use, but this is just to try to ensure that it's as fair as possible to the consumer so that you don't get stuck with a bad credit score.
Right, right. And so if the consumer wants to have their credit score reevaluated, like right now, they could request the insurance company to reconsider their rate.
They could, but the insurance company doesn't have to, as I understand it right now. But this would require a 3-year review, at least once every 3 years, to make sure it's updated.
And right now, how is one's credit score being used to determine the rate that the consumer is charged?
It depends on the underwriting model that each insurer uses. They're all different, and it's just basically what I would say is that if you have a lower credit score, it can adversely affect primarily your homeowner's rate, because they show a correlation, at least they assume a correlation between your credit score and how well you take care of your home. So all it does.
So if you have a lower credit score, it could increase your the rate that that insurance company charges you for that product.
Generally, that's speaking, that's true.
And so this bill would say that the underwriter is required every 3 years to reevaluate it. Now, do we know, I heard you say earlier, not all insurance companies use credit scores to help determine the rate?
No, my understanding is not all insurance companies do, but many of them do.
Do we at the Office of, what is it? The
Office of Public Insurance Counsel.
And they have a wonderful team there. I've met with them this year. Do we know which insurance companies do look at the credit score?
Yeah, TDI would have that underwriting. They have access, I think, to that information for each carrier. When the rates are filed, they get certain information about the underwriting model that's used.
Now, besides the credit score, does your bill address anything else that is considered? Like,
no, it relates primarily to the credit score.
so, but do we know if the insurance company is also considering where someone lives in the rates as well?
They consider a lot of things. They'll consider claims history, things like that, age. Like for auto insurance, they consider age of the driver, a lot of times whether the driver's male or female. And so they use a risk-based underwriting approach, which is designed to actuarially measure the risk that's being assumed.
So that's why I wanted to know about the credit score, like how much of a impact does it have? Because if you have all those other factors.
It depends on the carrier. It really all depends. All we're trying to do here is protect the consumer, so I'm just going to have to move passage.
Well, no, I think your bill is great. I just want to make sure that Texans understand it and why it's needed.
Well, I'd say just read the bill, and I think that'll explain it as well.
Well, no,
much
I
better
think
than
that-
I could ever explain it.
Well, I appreciate you taking the time because this is information that we can share with Texans about the importance of their credit score and how it impacts products that they have to purchase. So I appreciate you taking the time to answer these questions.
Well, I appreciate
I will
your
be voting for
questions,
the bill.
and so I would move passage.
The question occurs on passage of third reading. It's a record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 129 ayes, 4 nays. Senate Bill 1644 passed third reading. Chair lays out on second reading. Senate Bill 2217. Clerk, read the bill.
SB number 2217 by Hughes relating to certain election practices and procedures.
Mr. Shaheen.
Thank you, Mr. Speaker. Members, SB 2217 increases election transparency and consistency by requiring standardized election data reporting, reconciliation procedures, and system capabilities across the state of Texas. Currently, election data varies by jurisdiction, and this drives consistency across the state of Texas. I've got 2 amendments.
The following amendment, the clerk will read the amendment.
Amendment by Shaheen.
Mr. Shaheen.
Thank you, Mr. Speaker. Members, this amendment simply states at least 1% or more than 3 votes, whichever is greater, is used to determine the requirements that are tabulated on our ballots. The amendment is acceptable. I move adoption.
Mr. Shaheen sends up an amendment. It's acceptable to the author. Is there objection? Chair is none. It's adopted. Following amendment, the clerk will read the amendment. Mr. Busey, for what purpose?
I'm waiting on the amendment, sir. I was just waiting
Amendment
back
by
on that.
Patterson.
Mr. Patterson.
Mr. Speaker,
Mr. Busey, for what purpose?
I just wanted to see if the gentleman would answer some questions about what this amendment does.
I'll be more than
Gentleman
happy to
yield
answer
for
some
questions. He
for you,
yields
Mr.
for
Busey.
questions.
Can you explain your amendment to us a little bit?
Absolutely. So what this amendment does is it makes sure that in this elections bill and how our elections are conducted, that the number of votes cast for any candidate may not be determined using a method of counting that reassigns votes to candidates based on a voter's ranking of each candidate through a numerical designation from the candidate
Mr.
the voter
Speaker.
favors
For what
most.
purpose?
I raise a point of order under Rule Election 7-2 that the amendment is not germane.
Bring your point of order down front. The point of order has been withdrawn. The amendment has been withdrawn. Mr. Shaheen back on his bill.
Thank you, Mr. Speaker. I move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Mr. Busey voting aye. Mr. McQueenie voting aye. Ms. Weiner voting aye. Mr. Patterson voting aye. Ms. Jones Harris voting aye. Have all members voted? Have all members voted? 135 ayes, 0 nays. Senate Bill 2217 passed third reading. Chair lays out on second reading Senate Bill 2373. Clerk read the bill.
SB number 2373 by Johnson, relating to the financial exploitation or abuse of persons using artificially generated media or phishing communications, providing civil penalty, creating a criminal offense.
Mr. Capriglione.
Thank you, Mr. Speaker. Senate Bill 2373 modernizes Texas law by creating civil and criminal remedies specifically for AI-enabled financial exploitation. I have no amendments, so I move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? 131 ayes, 0 nays. Senate Bill 2373 passed third reading. Chair lays out on second reading Senate Bill 2431. Clerk read the bill.
SB number 2431 by Campbell, relating to requiring foreign language credit opportunities for students enrolled in study abroad programs offered by certain institutions of higher education in this state.
Ms. Howard.
Thank you, Mr. Speaker. Members, Senate Bill 2431 by Senator Campbell would require Texas universities, both public and private, to improve existing study abroad programs by providing an opportunity for students to participate in those programs to receive a foreign language credit while abroad. Move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Dr. Alverson voting aye. Have all members voted? Rosenthal voting aye. Have all members voted? 82 ayes, 55 nays. Senate Bill 2431 passed third reading. Chair lays out SB 1758. Clerk read the bill.
SB number 1758 by Birdwell, relating to the operation of cement kiln and the production of aggregates near a semiconductor wafer manufacturing facility.
Mr. Landgraf.
Thank you, Mr. Speaker. This bill establishes a pilot program in Grayson County, Texas.
Mr. Speaker.
Mr. Wu, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of SB 1758 under Rule 8, Section 1A1 of the House Rules on the grounds that the bill's caption does not provide reasonable notice of the subject of the proposed measure. And I call the second point of order against further consideration. Well, I'll save that one.
Bring your point of order down front. The point of order has been withdrawn. Mr. Landgraf on the bill.
Mr. Speaker.
Mr. Wu, for what purpose?
Mr. Speaker, I raise a point of order against further consideration of Senate Bill 1758 under Rule 8, Section 10B of the House Rules, and on the grounds that the bill is a prohibited local or special bill using an artificial device.
Bring your point of order down front. Mr. Wu raises a point of order against further consideration of Senate Bill 1758 under Rule 8, Section 10B on the grounds that the bill impermissibly limited in application to one or more political subdivisions by means of artificial devices. The bill has provisions that apply to only one particular area of the state. However, the bill author met his burden of showing that this area is a unique area for the development of advanced water manufacturing and industry of statewide importance, and thus the bill employs a reasonable classification scheme. Accordingly, the point of order is respectfully overruled. Mr. Landgraf. Mr. Toth, for what purpose?
Will the gentleman answer a quick question?
I'll yield for a question.
Will you tell me really briefly about your bill?
Well, Mr. Toth, you know this from sitting on the Environmental Regulation Committee.
Will you move passage?
I'll move passage. Move passage, Mr. Speaker.
The question occurs on passage third reading. It's a record vote. Clerk, ring the bell. Mr. Hunter voting aye. Mr. Fairley voting aye. Schatzline voting aye. Verdell voting aye. Schaffner voting aye. Mr. Wally voting aye. Have all members voted? Have all members voted? 108 ayes, 28 nays. Senate Bill 1758 passed third reading.
Coming back or not?
Chair recognizes Mr. Harris for a motion.
Mr. Speaker, I move to reconsider the vote by which Senate Bill 974 failed to pass on third reading.
Question.
Third reading.
Members, is there objection? Question occurs on the motion to reconsider. It's a record vote. Clerk, ring the bell. So Mr. Turner voting aye, Dr. Alverson voting aye, Mr. Harris voting aye, Mr. Hunter voting aye. Have all members voted? Have all members voted? 93 ayes, 47 nays. The motion to reconsider succeeds. Mr. Chair lays it. Chair lays out Senate Bill 974. Clerk, read the bill.
SB number 974 by Eckhart relating to eligibility of a person employed by a school district as a teacher to serve on the appraisal review board of an appraisal district.
Mr. Turner.
Thank you, Mr. Speaker. Members, first of all, thank you for voting for the motion to reconsider. And I want to just explain a couple things about this bill that I don't know that I explained clearly the first time. This is a bill that allows teachers to serve on appraisal review boards, often called ARBs. And the reason we have this bill is because under current law, employees of a taxing unit are ineligible to serve on an ARB, and there's a reason for that. However, we have learned in our committee, both in the subcommittee on property tax appraisals and in the Ways and Means Committee over the last few sessions, that many counties, particularly smaller rural counties, have difficulty filling their ARB roles during the summer months. And the ARB is the body that when a homeowner or another property owner wants to protest their appraisal, this is basically a panel of their peers, their fellow citizens, who looks at the data and helps them determine if their appraisal should be lower. So it's a really important role for our property owners and for our constituents. And teachers are ideal ARB members since most hearings occur, as I say, during the summer when teachers are not in school. And teachers are not in a decision-making mode in the school district. Even though they work in a governmental body, a governmental entity, they're not decision makers like a city executive would be. So this bill passed the legislature last session and in the House and the Senate. It got caught up in unrelated veto damage, and that's why we have it back. And I appreciate, again, Vice Chair Noble for the additional language we put in to strengthen
Ms.
this bill.
Troxler, for what purpose?
Will the gentleman yield for a
Gentleman
question?
yield for questions?
I'll yield, yes.
He yields for questions.
Is this the bill that includes up to a penalty for teachers? They could potentially go to jail?
It does not include a penalty for teachers, Ms. Troxler.
There's a civil penalty in the bill?
There is not.
Okay. So don't you think it's a conflict of interest for a teacher who works for a taxing entity to then serve on an appraisal review board where they are in charge of potentially the tax revenue that they are going to ultimately benefit from?
Well, Ms. Trostler, I appreciate the question, and we discussed this at length actually in our subcommittee, and that's the reason we have the additional language in the bill that's before the House right now that says first of all, there's already rules against ex parte communications to appraisal review board members. That's already in current statute. Secondly, in this bill, we have inserted language at Vice Chair Noble's suggestion, good suggestion, to say if a school district, a board member or an employee of the school district communicated with a teacher or attempted to communicate with a teacher serving this capacity about appraisal district business, that is a crime.
Well, it still sounds like a conflict of interest to me. It's 11:32. We have 28 minutes left.
Well, I'm ready to move passage, Ms. Troxler.
We have 28 minutes left.
I'm ready to move
to
passage
pass,
when you stop asking
and
questions.
we have spent this time reconsidering a bill that this body has already voted down, and other bills have died because of it. Voting no.
Thank you, members. I appreciate the reconsideration. I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Mr. Meyer voting aye. Mr. Leach voting aye. Mr. Harris voting aye. Mr. Turner voting aye. Dr. Alverson voting aye. Mr. Romero voting aye. Mr. Wilson voting aye. Have all members voted? Have all members voted? 94 ayes, 51 nays. Senate Bill 974 passes third reading. Chair lays out Senate Bill 505 as a matter of postponed business on second reading. The clerk will read the bill.
SB number 505 by Betancourt relating to the processes to address election irregularities, providing a civil penalty.
Chair recognizes Ms. Swanson.
To 11:30. We're doing some time up on it, so I was going to ask. I'm just telling you what.
I don't know. They told me to go ahead and try. Thank you, Mr. Speaker. Members, this bipartisan bill brings transparency and accountability in government. Move passage.
Mr. Busey, for what purpose?
Yeah, will the gentlelady yield for some questions?
Gentlelady for questions.
Yes. My question for you is, are you calling a point of order on this great bill?
No, I'm not. I have questions. Representative Swanson, can you explain what an irregularity in an election is under your bill? I think one of our big concerns
They told me to come
is
do it. They told
there's
me
no
to.
definition for what an irregularity is. So can you walk us through what that looks like to you?
I would be happy to. Hold on one second. Got so much information here for you. What? Oh, I thought you were trying to tell me something. Yeah, hold on.
Well, we're trying to. I can wait. Up, but we wait for like 15 minutes. You got 5 amendments, you got plenty of time to call them. You want to call it? Call it.
No, if you're right, if you know that.
Well, they're about to do it.
Let's do it.
Mr. Speaker,
Ms. Tallarico, for what purpose?
I raise a point of order against further consideration of Committee Substitute House Bill 505 under Rule 4, Section 41, and Rule 11, Section 2 of the House Rules on the grounds that a provision of the committee substitute is not germane to the bill.
Bring your point of order down front. The point of order has been withdrawn. Ms. Swanson for a motion.
Mr. Speaker, I move to postpone further consideration of SB 505 to June 3rd, 2025. It doesn't matter. I postponed.
They could not hear it.
Okay. Mr. Speaker, I move to postpone further consideration of SB 505 until June 3rd, 2025.
Members, you've heard the motion. Is there any objection? Chair hears none, so ordered. Schoolcraft for what purpose?
Mr. Speaker, who
Schoolcraft
has
for
the
what
floor?
purpose?
I'm waiting for the floor.
Okay. Chair lays out Senate Bill 2480. Clerk, read the bill.
SB number 2480 by Campbell, relating to the administration of the Texas Physician Health Program to disciplinary authority of the Texas Medical Board imposing a surcharge.
Dr. Alverson.
Thank you, Mr. Speaker. Members, Senate Bill 2480 fixes an oversight in last session's HB 1998 by making sure that the Texas Medical Board is able to continue to provide the
Mr.
Physician
Speaker?
Health Program.
Ms. Gonzalez, for what purpose?
Oh, will the gentleman yield?
Gentlemen yield for questions.
One question.
Yes, sir,
Gentleman
just one
yields for
question. I
questions.
appreciate you. Can you help us understand why you feel your bill is necessary?
It's next in the calendar. Yeah, move passage.
Thank you.
It occurs on passage of third reading of Senate Bill 2480. Clerk, ring the bell. Ms. Swanson voting aye, Mr. Hunter voting aye, Mr. Vasut voting aye, Mr. Schatzline voting aye. Have all members voted? Have all members voted? 129 ayes, 7 nays. Senate Bill 2480 passes to third reading. Chair lays out on second reading Senate Bill 3039. Clerk, read the bill.
SB number 3039 by West, relating to the transfer of students in public higher education.
Ms. Davis.
Mr. Speaker and members, this bill helps students in community and junior colleges avoid lost credit hours when they transfer to a four-year university. This bill has $0 fiscal note and will save our students money and time while helping them to graduate within 4 years. And there are two amendments.
The following amendment, the clerk will read the amendment.
Amendment by A. Davis of Dallas.
Ms. Davis.
This amendment was by the at the request of the governor's office to move the date from September to December 2025. I move adoption.
Ms. Davis sends up amendment. Record vote. Clerk, ring the bell. Hunter voting aye. Vasut voting aye. Have all members voted? Have all members voted? 102 ayes, 37 nays. The amendment is adopted. Following amendment. Clerk, read the amendment.
Amendment by Howard.
Ms. Howard.
Thank you, Mr. Speaker. This amendment ensures degree and certificate programs post prerequisites and non-course requirements, of course, internal student portals, public websites, and departmental pages. Move adoption. It's acceptable to the author.
Ms. Howard sends up amendment. It's settled to the author. Clerk, ring the bell. Have all members voted? Ms. Swanson voting no. Have all members voted? 82 ayes, 60 nays. The amendment is adopted. Ms. Davis.
Thank you, Mr. Speaker. I move passage.
Question occurs on passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Swanson voting no. Have all members voted? 82 ayes, 6 nays. Senate Bill 3039 passed third reading. Chair lays out on second reading Senate Bill 3047. Clerk, read the bill.
SB number 3047 by Zapparini, relating to the creation of the Pura Vida Municipal Management District Number 1, providing authority to issue bonds, providing authority to impose assessment fees and taxes, granting limited power of eminent domain.
Ms. Cole.
Members, this is the local MMD bill, and I have an amendment also.
Following
Move
amendment.
pass-
Clerk, read the amendment.
Amendment by Cole.
Ms. Cole.
This amendment removes the hotel occupancy tax and makes up for some drafting errors. I move passage, and I have another amendment.
Ms. Cole sends an amendment. Accepted the author. Record vote. Clerk, ring the bell. Ms. Cole voting aye. Have all members voted? Have all members voted? 89 ayes, 50 nays. The amendment is adopted. Following amendment. Clerk, read the amendment.
Amendment by Gerties.
Mr. Gerties.
Thank you. This is an amendment adds my bill to this, creating the Rivers Market MMD that's an elegant move adoption.
Mr. Gerties sends amendment. Settle the author. Record vote. Clerk ring the bell. If all members voted. Mr. Pursuit voting no. If all members happened. 94 ayes, 47 nays. The amendment is adopted. Following amendment. Clerk read the amendment.
Amendment by Harris.
Mr. Harris.
This is a Wolf Creek MMD, a move adoption.
Question occurs on the amendment. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? 83 ayes, 56 nays. Amendment is adopted. Ms. Cole to close.
Move passage.
Question occurs on passage. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? 84 ayes, 55 nays. Pass third reading. Chair lays out on second reading. Senate Bill 3073. Clerk read the bill.
SB number 3073 by Huffman, relating to the duty of a magistrate to make written findings in certain criminal proceedings.
Mr. Smithy. For a motion.
Mr. Speaker, members, this bill's already passed the House and the Senate, so I move to postpone further consideration of Senate Bill 3073 until June 5th, 2025.
Members, you heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading Senate Bill 2920. Clerk read the bill.
SB number 2920 by Campbell, relating to the regulation of steroid use by students participating in athletic competitions sponsored or sanctioned by the University Interscholastic League.
Ms. Lawson for a motion.
Mr. Speaker.
There's a motion.
Mr. Speaker, I lay out SB 2920, relating to the regulation of steroid use by students participating in athletic competitions. Mr. Speaker.
For what purpose?
We raise a point of order against further consideration of SB 2920.
Bring your point of order down front. Ms. Lawson for a motion. Point of order is withdrawn. Ms. Lawson for a motion.
Mr. Speaker, I move to postpone further consideration of SB 2920 until June 3rd, 2025.
Members, you've heard the motion. Is there objection? Chair is none, so ordered. Chair lays out on second reading Senate Bill 2781. Clerk read the bill.
SB number 2781 by Birdwell, relating to the imposition of civil penalties for certain violations with respect to political contributions and expenditures made by certain persons who engage in lobbying activities.
Mr. Shaheen.
Thank you, Mr. Speaker. Members, SB 2071 addresses enforcement of existing lobbying restrictions, placing a statutory cap. Move passage.
Question occurs on passage third reading. Record vote. Clerk ring the bell. Have all members voted? Have all members voted? Ms. Plessa voting aye. Have all members voted? 117 ayes, 24 nays, 27-81 passed third reading. Chair lays out on second reading Senate Bill 8026. Clerk read the bill.
SB number 826 by Parker, relating to the operation of a motor vehicle on a school zone crossing while intoxicated, increasing a criminal penalty.
Thank you, Mr. Speaker. Members, DWIs in active school zones are bad. Let's make them a felony. I move passage.
Question occurs on passage third reading. Record vote. Clerk read the bill. So Little voting aye. Have all members voted? Have all members voted? 132 ayes, 0 nays. Senate Bill 826 passed third reading. Chair lays out on second reading Senate Bill 766. Clerk read the bill.
SB number 766 by Zaffarini, relating to the correction of references to the Texas Natural Resource Conservation Commission.
Mr. Landgraf.
This finally, once and for all, gets rid of the TNRCC. I move passage.
Question occurs passed third reading. Record vote. Clerk read the bill. Ms. Plessa voting aye. Have all members voted? Have all members voted? 135 ayes, 1 nay, passed third reading. Chair lays out on second reading, 2460. Clerk, read the bill.
SB number 2460 by Creighton relating to rapid DNA analysis performed by certain law enforcement agencies and the content of certain DNA databases.
Ms. Plesser for a motion.
Thank you, Mr. Speaker and members. I move to postpone for further consideration of SB 2460 until my birthday, July 28, 2025.
Members, you heard the motion. Is there objection? Chair is none so ordered. Chair lays out on second reading, Senate Bill 527. Clerk, read the bill.
SB number 527 by Schwartner relating to health benefit coverage for general anesthesia in connection with certain pediatric dental services.
Dr. Albertson.
This bill provides dental anesthesia services for all children. Move passage.
Question occurs on passage third reading. Record vote. Clerk, read the bill. Have all members voted? Have all members voted? 108 ayes, 19 nays. It passes. Senate Bill 1946. Clerk, read the bill.
SB number 1946 by Zaffarini relating to the creation of Family Violence Criminal Homicide Prevention Task Force.
Mr. Manuel.
This is a domestic violence task force with the governor's office. Move passage.
Question occurs on passes third reading. Record vote. Clerk, read the bill. Have all members voted? Have all members voted? 87 ayes, 49 nays. Passed third reading. Chair lays out on second reading. 2885. Clerk, read the bill.
SB number 2885 by Flores relating to the use of reclaimed water that has been treated to meet certain standards as part of an aquifer storage and recovery project.
Dr. Buckley.
Reclaim water and ASR. Move passage.
Question occurs on passage third reading. Record vote. Clerk, read the bill. Have all members voted? Have all members voted? 121 ayes, 13 nays. Senate Bill passed third reading. Chair lays out on second reading. Senate Bill 1243. Clerk, read the bill.
SB number 1243 by Birdwell relating to the dissolution of a public utility agency.
Ms. Lawson.
Thank you, Mr. Speaker. This will dissolve a public utility agency. Move passage.
Question goes on past record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 123 ayes, 14 nays, passed third reading. Chair lays out on second reading. 2610. Clerk, read the bill.
SB number 2610 by Blanco relating to civil liability of business entities in connection with breach of system security.
Mr. Capriglione.
Cybersecurity legal safe
Mr.
harbor. Move
Speaker?
passage.
Ms. Zwiener, for what purpose?
Will the gentleman yield for some
Gentleman yield for
questions?
Yeah. No.
Mr. Speaker, I would like to speak for this bill.
Zwiener, come on down.
Thank you, Mr. Speaker, members. I really appreciate Representative Capriglione's commitment to making sure the civil liability for breach of security or for business entities in connection with the breach of a security system is well tailored and on point. So I urge your support of this fantastic bill. Vote yes.
Yes.
Question
Move
occurs on
passage.
passage third reading. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 125 ayes, 14 nays. Senate Bill 2610 passed third reading. Chair lays out on third reading. Bill 2595. Clerk, read the bill.
SB number 2595 by Middleton relating to the creation of criminal offense of harassing, intimidating, or threatening another person while concealing identity with a mask or other headgear.
Dr. Alverson for a motion.
Mr. Speaker, I move to postpone further consideration of Senate Bill 2595 until June 3rd of 2025.
Members, you've heard the motion. Is there objection? Chair is none so ordered. Chair lays out on second reading. Senate Bill 857. Clerk, read the bill.
SB number 857 by Schwartner relating to the authorized removal of certain motor vehicles.
Mr. Louderback.
Senate Bill 857 by Senator Schwartner grants law enforcement officers discretion to tow vehicles. Move passage.
Question occurs on passage third reading. Record vote. Clerk, read the bill. Have all members voted? Have all members voted? 82 ayes, 60 nays, passed third reading. Chair lays out on second reading. Senate Bill 2501. Clerk, read the bill.
SB number 2501 by Zaffarini relating to a selection of attorney by the indigent parent for the appointment of attorney ad litem for the parent of
Mr.
intern
Landgraf.
of suits affecting relationship.
Mr. Landgraf.
Better Sapsers, move passage.
Question occurs on passage third reading. Record vote. Clerk, read the bill. Have all members voted? Have all members voted? 117 ayes, 13 nays, passed third reading. Chair lays out Senate Bill 66. Clerk, read the bill.
SB number 66 by Zaffarini relating to the authority of supporter regarding legal proceedings granted under a supported decision-making agreement.
Mr. Leach.
On behalf of the
Mr.
great
Speaker.
and the record-breaking Senator
Mr. Speaker.
Zaffarini, I move passage of Senate Bill 66.
Mr. Speaker.
For what purpose?
Gentlemen yield.
Yield for questions?
No. Move passage on behalf of Senator Zaffarini.
Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 111 ayes, 24 nays, passed third reading. Chair lays out on second reading. Senate Bill 268. Clerk, read the bill.
SB number 268 by Perry relating to the procedure for certain complaints against healthcare practitioners.
Ms. Howard.
Mr. Speaker, members, I am bringing a bill here to relating to the procedure for certain complaints against healthcare practitioners. Move passage.
Following amendment. Clerk, read the amendment.
Amendment by Oliverson.
Great
Dr.
amendment.
Alverson.
She loves it. Move adoption.
Record vote on the amendment. Clerk, ring the bell. Have all members voted? Have all members voted? 101 ayes, 29 nays. Passes. Dr. Howard.
Move passage.
Question occurs. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? Have all members voted? 69 ayes, 50 nays. Pass third reading. Chair lays out on second reading. Senate Bill 331. Clerk, read the bill.
SB number 331 by co-course relating to the disclosure of healthcare costs and information by certain healthcare facilities imposing an administrative penalty.
Mr. Frank.
Expand transparency. Move passage.
Question occurs. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 110 ayes, 11 nays. Pass third reading. Chair lays out second reading. 618.
Mr. Speaker.
SB number 618 by Sparks.
Mr. Speaker.
Mr. Dutton, for what purpose?
I have a message from the legislative Grim Reaper.
Admit the Grim Reaper.
And he says, I raise a point of order against further consideration of this bill under Rule 8, Section 13B, in that the time for consideration of Senate bills on second reading on the supplemental daily House calendar has done expired.
Mr. Dutton, your point of order is well taken and sustained. Chair announces the signing of the following in the presence of the House.
SB number 20, SB number 33, SB number 75, SB number 213, SB number 227, SB number 269, SB number 458, SB number 528, SB number 647, SB number 648, SB number 681, SB number 740, SB number 835, SB number 840, SB number 843, SB number 1061, SB number 1120, SB number 1121, SB number 1150, SB number 1202, SB number 1253, SB number 1535, SB number 1574, SB number 1709, SB number 1789, SB number 2037, SB number 2078, SB number 2544, and SB number 2570.
Members, the Speaker's desk is clear. Mr. Dutton moves the House recess until 10 a.m. Wednesday. Is there objection? Chair hears none. The House stands recessed.